Magandang hapon. Ito, balik na naman tayo. At ating panoorin na naman yung continuation ng hearing na kung saan ay wala pa rin, hindi pa rin binibigyan ng tinatawag na katitig na pag-asa na marinig man lamang si Sara Duterte sa pamamagitan ng kanyang abogado. So, useless ang tinatawag niya mini trial ay no trial pala. So, anong klase itong si Luistro? Dito, pangalawang pagkataon ito para sabihin natin na nagsisinungaling ito at hindi makatotohanan si Luistro sa kanyang sarili. Kaya kayo mga taga-distrikto ng Batangas, huwag nyo na pong iboto ito. Sa totoo lang, inuubos niya lang ang pera. Siya lang yung mayaman din sa distrikto ng Batangas. Bakit nyo kasi binuboto pa ito? Sa salita sisigaw, walang AX kung wala ni speaker. Walang akap kung wala ni speaker. Anhin mo yung talino ng tao kung magnanakaw. Magnanakaw pala siya. So pakinggan natin ito, continuation, kung saan sinusupil nila ang katiting na karapatan ng Vice Presidente na magtanong man lamang sa kanilang mga testigo. Wala. Desisyon na nila yun. Nasa kanila na lang yun. Sila ang may kapangyarihan, sila magdedesisyon kung paano nila gaganapin ang kanilang kapangyarihan. Sana man lang naisip man lang nila, yung kinakasuhan nila ay hindi ordinaryong tao na kinakasuhan sa Office of the Prosecutor ng kasong murder o kasong anong kaso pa, rape pa o whatever. Ang dinedesisyonan nila na kakasuhan ay yung hinalal ng 32 na milyon na tao noong 2022 election. Makatarungan ba yun para sa kanila? Na ang mga tao po ang kinukontra nila, hindi si Sara. Ang mga botante ni Sara ang kinukontra nila, hindi si Sara. Yun dapat tandaan nila. So, ito pakinggan natin kung paano natin sila gagantihan sa 2028 na halalan ay pakinggan niyo po.
Fortuna Narvasa Salazar and Attorney Michael Wesley Poa.
Madam Chair.
Second. That is a motion for, if I may be clarified.
Ground rules as amended by the Honorable Jokno, and I would like to point out that these are just ground rules and not rules of the House of Representatives. These are just the ground rules of the Committee on Justice.
With the acceptance by the proposal.
Inamin niya ground rules ng Committee on Justice, pero yan ang gagamitin nila sa pagsaganap ng kanilang kapangyarihan na ibinigay ng House of Representatives. Ibig sabihin, kinontra nila mismo yung utos ng House impeachment rules.
Opponent of the amendment by the Honorable Jokno, may I hear the necessary motion to approve the amended ground rules? Vice Chair Zamora.
So move, Madam Chair.
Second, Madam Chair.
There is a motion to approve the amended ground rules by the Honorable Dumogan. It has been seconded. Is there any objection? Hearing none, the amended ground rules is hereby approved. Now we proceed to the next matter. Earlier, the Honorable Redon is manifesting a letter received from Fortuna Narvasa Law Office. Now we recognize the Honorable Redon for that matter.
Madam Chair, the counsels of Vice President Sara Duterte, Fortuna Narvasa Salazar, and Attorney Michael Wesley Poa submitted a letter explaining the Vice President's absence today and their absence as well as counsels for the Vice President. And I will read the main basis for their objection to attending today. Under these circumstances and considering the public statements made by the chairperson, it appears that the committee intends to conduct a trial. I think, Madam Chair, the House Committee on Justice should confront this
Conduct a trial, tinawag niya conduct a trial, tapos walang karapatan ang abogado ni Sara at saka si Sara na magtanong sa mga testigo ninyo laban sa kanya. Kabubuhan ito. O lumalaki ang kanyang yung kanyang pisngi. Talaga Mr. Bean talaga, cookie, ha? By
squarely
the way, ito si Terry Ridon, tinanggal ito ni Duterte noon mula sa pagiging chairman ng Philippine ah, Presidential Commission of the Urban for the Urban Poor. Siyang chairman, tinanggal siya. Ang katwiran na nila kay corrupt, nagpakita 7 beses bubiyahe sa abroad kagad. Itong dahilan kung bakit tinanggal siya. Sabi sabihin, napaka-corrupt na tao ito si Ridon. Nagkunwari siya na makakaliwa.
today. This particular position of the councils and of the Vice President herself is basically a legal word salad. Ibig sabihin po, wala po itong batayan sa katotohanan.
Sige, Flores Jesse, sasagutin ko lang po sinasabi nyo. Sila mismo nag-open, nagsabi sila ni Luistro na walang karapatan ang abogado ni SARA at saka si SARA na magtanong. Yan po ang dahilan nila ni SARA at saka mga abogado niya. Kaya sumurat sila na hindi sila a-attend. Dahil wala man lang silang karapatan. Ano, papalakpak na lamang sila? Pakabubo mo naman, Flores Jesse.
Ito po ay legal na pagpapalusot para
Legal na pagpalusot. Tarantado ka talaga. Sinayang mo lang ang pera namin, pera ng bayan, na binayad sa tuition mo sa University of the Philippines College of Law. Tapos ganun ka lang, tarantado ka.
lusutan na naman pong muli ang pagpapanagot sa mga impeachable offenses laban sa atin pong pangalawang Pangulo. Yung pong paggamit ng mini trial ng ilan po sa mga kinatawan
Paggamit, do not call it mini trial, tarantado, gusto ko sampalin mo ka po eh.
ng komite pong ito ay para lamang po sa pagpapaliwanag sa atin pong mga kababayan nung pong pagtakbo.
Bahala kayo, managot sa taong bayan. Party list ka na, mga Bicolano, huwag nyo na iboto to. Sinisira na lang ang lahi ng Bicolano nito. Putangin ng tundiridor na to.
ng proseso po na
Unang-una, hindi naman ito nakatira sa Bicol eh. Sa Quezon City ito nakatira eh. Hindi na ito Bicolano.
impeachment. Particular, ito pong hearing proper at more particularly to make a distinction from the actual trial which will happen at the Senate. No? So, tingin ko yun lang po yung malinaw po na distinction dito po sa bagay po na ito. And Madam Chair, there is nothing in the rules and the proceedings that we have today which can in fact be considered as unconstitutional. I will read for the record the rules yet again and the constitutional provision. The constitutional provision in
Ikaw
Article
naman, Ben Reclamador, huwag ka mapakita ng kabubuhan mo. Mali yan. Sasagutin ni BP ang akusasyon sa kanya, bakit tatanungin nga niya mga akusasyon laban sa kanya? Tarantado ka ba? Kasama, pag ikaw kinasuhan, Ben Reclamador, pag hindi ka binigyan ng karapatan magtanong sa umakusa sa iyo, ano? Irereklamo ka ba? Iiyak ka ba o hindi? Kabubuk. Ang bobo mo talaga na tao ka.
9, Accountability of Public Officers, Section 3, 2. A verified complaint for impeachment may be filed by any member of the House of Representatives or by a citizen upon a resolution of endorsement by any member thereof, which shall be included in the order of business within 10 session days and referred to the proper committee within 3 session days thereafter. The committee, after hearing, this hearing, Madam Chair, and by a majority vote of all its members, shall submit its report to the House within 60 session days from such referral together with the corresponding resolution. That is the constitutional provision, Madam Chair. The rules of impeachment of the 20th Congress, Section 7, submission of evidence and memoranda. If the committee finds that sufficient grounds for impeachment exist, the committee shall conduct a hearing. This hearing, Madam Chair.
Mali ka. Ang pagbasa mo may salita kang hindi binabanggit, gago ka talaga. Ang nakasabi diyan, nakasulat diyan sa inyong impeachment rules, if the committee finds the allegations of sufficient grounds, if the allegations are sufficient in grounds, kung aligasyon, kwento lang, hindi yung sufficiency in grounds. Tarantado ka. Oh,
The committee, through the chairperson, may limit the period of examination and cross-examination by members of the committee. The committee shall have the power to issue compulsory processes for the attendance of witnesses and the production of documents and other related evidence. These are particular provisions which
so, binasa mong batas ninyo, wala pong nagkalagay dyan na babawalan mo ang abogado na magtanong. Ang nilalagay lamang dyan sa probeso ay yung kung ang mga committee members na magtatanong, may limitasyon tag 5 minuto bawat isa o ano man. Pero walang nakalagay dyan na bawal ang mga abogado nang inaakusahan ninyo. Katarantado. Kayo nga dito, ang nangyari dito ay mahilig kayo mag-abuso ng kapangyarihan ninyo. Okay, wala makapigil sa inyo. Titingnan lang. So ngayon, nakikita ko na po na kayo ang nagbibigay ng dahilan para si SARA ay aakyat sa Supreme Court. Bahala kayo sa buhay niyo.
the hearing proper today. And therefore, Madam Chair, hearing is mentioned in both the Constitution and the rules. This is the hearing proper that is mentioned in the Constitution and the rules. And part of hearing, any hearing, is the receipt of evidence. Ang sinasabi po ng mga abogado ng pangalawang Pangulo, wala daw pong karapatan ang komite pong ito sa yugtong ito na tumanggap po ng mga ebidensya. Pero alam po natin na sa mga pagdinig, bahagi po ng mga pagdinig ang pagkuha po ng mga ebidensya. Make no
Napakabobo mo, Flores Jesse. You are, salita ka pa, you are on the wrong side of history. Hey! Anong utak mo? Hindi ka naman abogado. Kung abogado ka, pakita mo mga rason na sinasabi mo. Putsang ina. Tarantado ka talaga. Anti-SARA ka lang, anti-Duterte ka lang, kahit gano'n salita mo, Flores JC. You are not being fair. You are only manifesting your desire to kill Sara Duterte. Ganun lang po yan.
mistake, Madam Chair, the committee will fulfill its constitutional mandate to conduct hearings in the context of impeachment. More importantly, make no mistake, we will receive evidence during these hearings.
Pinamaliit niya si Sara Duterte doon na mababa ang utak. Ang pinakita ko, Flores Jesse, kung babae ka man o lalaki, yung salita mo rito shows how intelligent you are, and your intelligence is very low.
Subpoenas of all the witnesses and documents will be issued. The subpoenas on the audit reports and congressional records will be issued. The subpoenas on the SALNs, on the bank records, on the tax documents, on the businesses, corporate records.
I've been reklamador, hindi po yan sapat na magsabit ng question. Tapos si Luistro magdidesisyon kung itatanong ang question. Hindi po yan pwede. Kailangan full right to question. Kabubuhan yan, reklamador, ang inano mo. Kala mo, tama ka? Hindi ka po tama. Mali po yan sinasabi mo.
Of the Duterte Carpio couple and their business interests placed in the SALNs of 2024 will be issued. We will fulfill this mandate today, Madam Chair, until the very end
Galit na galit ka sa Duterte kasi tinanggal ka ni Digong.
of these proceedings. Yun lamang po. Maraming salamat.
Just for the record, the use of mini trial by some members of the Justice Committee is intended only to make a distinction between the proceeding before the Justice Committee and the trial which will happen in the Senate. Let us always be reminded that our parameter in our hearing proper is the determination of probable cause only, which means the justification to be able to proceed to trial. Again, we are not yet determining the guilt. We are not holding trial. This is just a clarificatory hearing for the purpose of determining probable cause, which will allow us to proceed to trial in the Senate.
Madam Chair.
That is for the record. The
Madam
Honorable
Chair.
Ko.
Madam Chair.
Madam Chair, a comment.
The Honorable Ko and then the Honorable D.S. Puno.
Madam Chair, also for the record, there is a statement released by the Office of the Vice President, no, echoing the parts of the letter issued by counsel, and again using the word quote unquote mini trial. Madam Chair, on the record, I'd like to contest, no, and express my grievance on the use of the word mini trial. What is happening on the floor, Madam Chair, is determination of probable cause. It is a different, no, proceeding that if you also
bakit sino pa nagsabi mini trial? Si Luistro at kayo. Tapos ngayon, ang ginagamit ang salitang mini trial laban sa inyo. Laban sa magpaputista kayo. Ipapakita ko kay interview kay Luistro na siya nagsabi ng mini trial.
provide equivalence in how we do this in the judicial proceedings. Clear naman po ang distinction ng ginagawa ng Office of the Prosecutor. And kapag nahanap na po yung probable cause na yon, magpo-proceed na po sa trial sa korte. For me, Madam Chair, it is irresponsible to muddy legal concepts so as to create a reason para po hindi mag-appear and even defeat the capabilities of this committee to talk about evidence, pleadings that is provided and may avenue naman na pinapadaloy under our House rules. So, Madam Chair, I'd just like to put on the record yung grievance on the use of the word mini trial. Thank you, Madam Chair.
Thank you. The Honorable D.S. Puno.
Thank you, Madam Chair. I refer back to the comment earlier by Congressman Jokno, which I think is very important, that we try to be sensitive to any actions that the committee takes that might open us to questioning on the higher judicial levels. We are in a hearing today. Hearings usually result in committee reports. Committee reports that will not have a judgment, that will not have any statement on the true veracity of any evidence that is presented here, because that is the work and job of the Senate, in my belief. No? So the final report that comes out is not a decision, it is not a judgment, it is a committee report that is forwarded to the Senate and recommending a trial. So I believe that the distinction between whether we are having a trial or not should begin there. And that is where we should rest it, not on the dictionary meaning of trial and so on and so forth. So the use of these terms, while sometimes unfortunate, does not result in nullifying the importance of these proceedings. So even the evidence that we review here, we will examine so that we do not send to the Senate meaningless evidence. It must be evidence that is germane to the complaints that have been filed, and it must be evidence that we have verified to be real facts and not just allegations, not just versions of the truth, but something that we all know is actually the truth, because why would we send it to the Senate if we do not believe that that is the case? So I believe that if we clarify this in the course of our proceedings, that we are not judging any testimony, but merely verifying it for purposes of accuracy, relevance to the complaint that has been filed, and so on, and come out with a committee report in that manner, I don't think that this committee can be accused of conducting a trial, Madam Chair.
Madam Chair.
The Honorable De Lima first, and then the Honorable Rodriguez. Rodriguez Roge.
Yes, Madam Chair, just a brief reaction to the manifestation of the Honorable Representative Puno. Just to be very clear, what will be transmitted to the Senate is not the committee report. What is to be transmitted to the Senate is the articles of impeachment already. The committee report from this committee will be transmitted to the NBank for consideration of the recommendation, for the consideration and approval of the recommendation of this committee, whether probable cause exists or not. So let's just be very clear about it. And Madam Chair, I noticed that the ground rules, the guidelines distributed to us does not yet reflect the amendment. So if we can have, please,
The
copy
committee
reflecting-
secretary is directed to reflect or include the amendment that was approved already in the approved ground rules.
Thank you.
Are you finished with your manifestation, Honorable De Lima?
Madam Chair, another point. Can we have a confirmation from the committee secretariat that indeed respondent SARA Duterte and her counsels were duly notified of today's proceedings? Second, if so, is there any communication or anything, a pleading, a communication filed or submitted to the committee secretariat saying categorically that they are not appearing in today's hearing or in today's proceedings? And another question is there also any communication or any submission made from their camp explaining the absence of respondent Sara Duterte? Because aside from the letter put on record by the Honorable Terry Ridon about questioning the proceedings under the erroneous premise that what is being conducted here is trial on the merits, is there has been statements, pahayag, from Sara Duterte. I think this was circulated already to media. Let me just point out one important statement here. It's a pahayag from the Vice President of the Philippines, Sara Duterte, dated today, March 25. The second to the last paragraph says, naisumit ko na ang aking answer ad cautelam. Sa ngayon, wala nang dapat pang gawin ng komite, kundi ibasura ang mga reklamo dahil sa malinaw na kakulangan ng ebidensya. Is this an indication clear enough that she is waiving her right to participate in our proceedings? So I just wish to have that confirmation of the committee secretariat as to whether there's been any formal communication saying that they will not, whether she or by her counsel, will not participate in the proceedings before this committee henceforth.
The committee secretariat is directed to report to the committee the fact of having sent the notice of today's hearing to the respondent and whether there is a communication or a document filed in relation to that invitation, as well as the same letter which was earlier manifested by the Honorable Ridon. And if there are any other documents received from the respondent, the committee secretariat is likewise directed to report to the committee. Let's begin with the notice sent to the respondent. Comsec, please.
Yes, thank you, Your Honor. The invitation for Vice President Sara Duterte to attend today's initial hearing was sent by electronic mail on March 19, 2026 at 10:25 a.m. It was acknowledged by, it was received March 19, 2026, 12:34, and acknowledged by the Central Records Unit of the Office of the Vice President. The invitation for two Nervasa and Salazar, counsel for Vice President Sara Duterte, to attend today's meeting was emailed on March 19, 2026, 10:21 a.m. received March 19, 2026, 1:45 p.m. acknowledged by Fortune Narvasa Salazar. As far as the any communication from the Office of the Vice President um, manifesting that she will not attend today's initial hearing, the only communication we received with respect to that is the letter from her counsel, Fortune Narvasa and Salazar. That's all, Your Honor.
Any comment from the Honorable De Lima?
Thank you, Madam Chair. It's very unfortunate that the respondent herself is disrespecting the proceedings before this committee. At the very least, she should have manifested formally that she will not be appearing before this committee, and rather than just issuing statements before the media, because that letter submitted by her counsel, the Fortune Law Office, is not yet very clear there. Are they appearing or not? Show respect. They cannot just assume that this is going to be a trial, because it's already clarified that it is not full-blown trial. This is not trial on the merits, but simply akin to preliminary investigation, with, of course, right to counsel, right to appear, right to assist the clients, and right to submit clarificatory questions to the Honorable Chair. So this is disrespect, another manifestation of her affront the constitutional process. I remember what the Honorable Chair cited earlier in her opening remarks. There's this quote from former Supreme Court Justice, I think it's Noel Tiham, not Antonio Tiham, as stated earlier, about the fact that failure to appear, failure to participate in the impeachment proceedings, it's itself a betrayal of public trust, because this is a formal constitutional process that everyone is expected to respect, especially the parties like the respondents. So it is very unfortunate that we have this mindset again, this attitude on the part of the respondent, showing disrespect and affront to the constitutional process of impeachment. Thank you.
Thank you. Now the Honorable Rog Gutierrez.
Thank you, Madam Chair. Madam Chair, I believe the Honorable De Lima has made some good points, and we were actually moving on with the discussion. But I just wanted to go back po, just a short manifestation on dun sa issue ng mini trial, because this representation agrees with our colleagues here today that I think we should confront, I think was the term used, this framing of what is going on here today. Kasi Madam Chair, we take exception to this because I think it does not have any legal effect the way that it was called a mini trial. If ever even it was mentioned in passing, I would assume it was never in any official memo, but it shouldn't have any legal effect. No amount of nomenclature can change the proceedings that we're having here. And actually, I believe, Madam Chair, what should be controlling is the letter that actually this committee has submitted to the party of the respondent. And I believe we have here, it is reflected in the letter, March 19, 2026, letter invitation to the Vice President at the March 25, 2026 committee hearing intends to discuss the Zabalya and Cabrera impeachment complaints, as well as administrative matters. This includes the setting of ground rules, acting on request for subpoena, scheduling hearing dates, identifying witnesses to be invited for the next hearing to ensure efficient and orderly proceedings. These, Madam Chair, are matters germane precisely to the functions of this House as that body in which the impeachment proceedings are to be initiated. This is not in any way close to a trial, even if we call it a trial. Tanggalin na po natin yung mini doon. Sabihin natin we called it a trial. What we're having here today is very far from that. As mentioned, I think it was Justice Carpio who once mentioned in a concurring opinion that, and it has been thrown around here a lot, no? It is akin to a preliminary investigation. And very clear if we are even to compare to that under Rule 112, Section 3, Paragraph E, they have their actually clarificatory hearings. So no matter any which way that we call this proceeding, very clear po na this hearing that we're having, if it's going to be considered akin to that, is nowhere near an actual trial by any judicial body. So I think, Madam Chair, we really have to dispel that framing na this is a mini trial or a trial. it's very far from the truth of what is going on here. And I think si Deputy Speaker Puno made some fine points na what the goal of the hearing that we're having here is very different. In fact, what will be presented here will be different from what will be presented in a trial, should it proceed to that. So, Madam Chair, I just want to, again, manifest, make it clear, I join our colleagues in debunking this mini trial categorization. And in fact, what we're doing here is constitutionally mandated. I believe it was mentioned very clearly. There is the provision that it
Ibig sabihin lang po, na problema sila ngayon sa kanilang ginawa. Sila ang nagkwento na mini trial yun. Si Luis Tro laging nagsasalita sa mga media na nag-interview sa kanya na mini trial daw yun. Tapos sila ngayon na problema kasi nang tinawag, nagpahayag si dating pangalawang Pangulo Sara Duterte sa publiko sa kanyang inilabas na pahayag na tinuligsa niya na tinawag ninyo yan na mini trial pero wala kaming karapatan na sumagot. So yan po. Na problema ngayon itong mga congressmen. Sabi sino ba sa atin ang nagsabi na mini trial ito? Ito ngayon ang pinaka-problema nila dinidiscuss nila. Natanggalin daw yung tinatawag na statement nila na kung sino man nagtawag na mini trial yan. Kaya ito sila na problema ngayon. Sila mismo nagbigay ng bato pabukpok sa kanilang ulo.
is only after hearing, and a majority vote of all its members that committee shall submit its report to the House within 60 session days from such referral. This is about the constitutional provision on impeachment, po, Madam Chair. So very clear, we're all moving. This procedure is moving within the pace as provided by the Constitution, as you know, clarified by the Supreme Court in this most recent ruling. So again, Madam Chair, I join our colleagues. Thank you.
If there are no other manifestations on the letter sent by the counsels of the respondent,
Madam
we shall
Chair.
proceed to the next matter.
Mr. Chairman,
The Honorable Vice Chair Dumogan and then the Honorable Rodriguez. Rufus.
thank you, Madam Chair. What is important to me is notice had been sent to respondent in her counsel. And there is conclusive proof of receipt. Hence, this committee has complied with the element of due process. Unfortunate, that has already been said, she does not recognize the proceedings in this committee. Most important, you were duly notified of today's proceedings, but did not appear. Thank you, Madam Chair.
The Honorable Rufus Rodriguez.
Madam Chair, if I was so disappointed by the answer, consolidated answer ad Colteram, I am really totally dismayed by this letter sent by the lawyers. We have here 6 lawyers who has submitted a letter to the Honorable Chairperson, Jervil Luistro, that we have no jurisdiction to conduct this hearing, which they term as mini trial. Madam Chair, in the first page of the letter, March 24, 2026, it says, the Constitution vests the authority and power to conduct trial solely in the Senate. Clearly, what applies here is the constitutional provision that in the impeachment proceedings, we will have a hearing. It is not a trial. That is very much clear under our Constitution. They are citing here Section 3(8), Article 11 of the Constitution, the state shall have the sole power to try and decide all cases of impeachment. That is right. But we are governed not on the hearing by the Senate, but we are governed by the proceedings on impeaching to find out probable cause. Then, Madam Chair, in this letter, the second page, it says, the same, Article 3 to 11, the same does not give the committee any power or jurisdiction. Can you imagine that? How can they be able to support this allegation that the committee has no power or jurisdiction to conduct any form of trial, mini or full-blown, because precisely we are not having a trial here on the merits, but only, Madam Chair, on a hearing to determine probable cause. And then it also says that it is basic that all rules must not contravene. We are not the committee is not contravening the Constitution nor our rules or any law for that matter. And then finally it says, Madam Chair, that on the ground they're saying that we have no authority and jurisdiction on the ground that the committee and or the HOR as well as any of its members lack jurisdiction to conduct any form of trial or exercise of its incidents. Any law student would know that precisely our committee has the power to hear on finding probable cause by the two complaints where we found sufficiency in form, substance, and grounds. Therefore, I move that we issue an order traversing these particular erroneous allegations in this letter. Erroneous because they are the ones contravening the Constitution. The lawyers of the Vice President are the ones contravening our rules of impeachment. But then, in that letter, we invite them again to appear in the next hearing because we are always mindful of giving due process. So move, Mr. Chairman. Let us answer this by this committee.
Second.
We should answer that these are all erroneous and is not in compliance, is against the Constitution itself, which they are citing. And then be giving them due process. I am disappointed, Madam Chair. This is the chance of the Vice President. In their answer, they did not put forth. I thought it was a strategy that in the hearing, they'll be able to appear. Although, Madam Chair, I don't agree that we should have the Vice President appear here, but counsel should appear and be able to traverse all the 6 grounds of the 3rd complaint and the 5 grounds of the 5th complaint. So I move that we issue an order traversing this, saying that these are all erroneous and that they, in spite of their erroneous interpretation of the Constitution, they are invited to the next hearing if they so mind, because it's clear, our ground rules are clear, the lawyers are
May
able
we
to...
be clarified on
Yes.
the purpose of your motion of inviting the lawyers in relation to the letter that they sent to us?
Also that, and probably, but no, Madam Chair, very clearly, the letter has no basis in law, on the Constitution, and our rules. We don't have to let them here to explain. I'm saying that we should be able to tell the lawyers that this is really a scrap of paper that they have submitted to this honorable committee. It's an insult to the committee if this is what they want. And so therefore, we have an order from the committee for them to tell them that they are wrong and that they are invited in the next hearing so that we continue to try to give due process to the Vice President, which we wanted precisely to have her side on these grounds. Thank you.
Your
moved,
motion,
Madam Chair.
Honorable Rodriguez, is to invite the lawyers to answer to the committee about the erroneous impression that they're giving about the proceeding of the Justice Committee. Is that your motion?
No, not anymore. They have already stated this. What I'm saying is that you have an order denying this manifestation and putting our reasons why their letter dated March 24 has no basis in the Constitution, the rules, and the law. And then at the same time, invite them to attend the next hearing so that if they're minded,
We are
to send
inviting the
Yeah.
parties and the councils every time we have a hearing.
Chair. But in this case, they are saying that they do not recognize our jurisdiction. And so we're telling them that please come and recognize it because your premises here is totally unfounded and baseless. Thank you.
All right, so there is a motion to issue
Madam
an
Chair.
order
Madam Chair.
or an answer to the letter belying all the erroneous allegations contained in the letter of Fortuna Narvasa. Do I hear a second?
Madam Chair, amendment.
it is not, we do not answer. We order. So it will not be, the committee will not answering anybody.
Yeah.
It will be an order because we have the jurisdiction to order by stating that they have no basis and they are invited to appear. Thank you,
Madam
but
Chair,
it depends.
There
on the
is a
chair.
motion to issue an order to the councils of the respondent to attend in our subsequent hearings because all their allegations are erroneous. I am
Amendment
pertaining to the
motion.
letter sent by Fortuna Narvasa.
amendment to the motion, Madam Chair.
The Honorable DS Puno is recognized.
Yes, may I recommend that in the manifest in the amendment that we state that this matter was discussed at this hearing and found to be defective and erroneous. So I think that those statements of Representative Rodriguez should be included in the order, and then the invitation. But I think we should make it clear that it was discussed, just so that it's not made to seem later on that it was dismissed without due deliberation here.
Madam Chair, may I?
Is
just,
this in relation
yeah,
also to
yeah.
the motion? The Honorable Zia
Yeah,
Alonto Adjong.
Before we act on the motion, Madam Chair, just for the public consumption, because our kababayans are watching us right now, the order as proposed by Congressman Rufus Rodriguez should not be taken as something for this committee to treat the lawyers with an equal footing, because the legitimacy of this process does not rely on the acceptance or recognition of these lawyers, or anyone for that matter. We are exercising our constitutional duty to proceed with the investigation, with the hearing as we are conducting right now. Para po sa kaalaman ng karamihan, yung sinasabi po ni Congressman Rufus Rodriguez is not really in response to put them in the equal footing as though the lawyers and this committee is exchanging ideas or opinions. Because number one, hindi po nakasalalay ang integridad, ang proseso at legitimacy ng hearing na ito sa acknowledgement, recognition ng sino man o kanino mang parte, Madam Speaker.
Madam Chair, the letter was submitted
The Honorable DS Puno.
to the chairperson as chairman.
It is addressed to the
addressed to the
chairperson, DS
chairperson
Puno.
as chairperson of the committee.
That's correct.
So I think at the very least we should manifest that this has been brought out to the members. It has been read by Representative Ridon, and it has been commented upon by Congressman Rufus Rodriguez. That does not make them and give them equal status with us. It merely tells them that we are fair, and we have taken this into consideration and actually found their manifestations and their letter to be defective in substance, no, in what
Madam
they
Chair.
allege.
Madam Chair.
The Honorable Jokno.
Yes, I have some serious reservations about using the term order because it could be twisted and made to appear that we are acting like a court. I would agree that we should respond to the letter since it was addressed to the chair. Perhaps the chair could synthesize all of the discussions made today. And if I may add on that point, we are exercising a constitutional duty today and in succeeding hearings to conduct a hearing. And we have gone through all of the form and substance. We have already made the finding that there's sufficient ground to proceed with the impeachment proceedings. So what else do we have to do except to look at the evidence? Yan po yung tungkulin natin. And it must be clear to the public and to the lawyers of the Vice President that that is what we are doing today. Thank you.
So the
Madam Chair.
suggestion of the Honorable Jokno is instead of an order of the committee, that the chairperson answer the letter of Fortuna Vasa. Let's hear the comment of the proponent, the Honorable Rodriguez.
Madam Chair, the issue has been brought to the committee. It's not anymore, the letter is addressed to you, but precisely the issue has been discussed by the committee proper. And so it therefore should be an order, not a singular letter from the chairman, so that it is clear that that is the position of the committee, that we're ordering that they appear and that we are saying in that order that all their allegations, all their statements here are erroneous, have no basis in the Constitution, in law, and in fact. Thank you, Madam Chair.
Any other comment from the Honorable Jokno? Are you now amenable to the...
Okay, yung pinag-usapan nila niyan ng mini trial na sumama yung loob nila dahil ginagamit ang salitang mini trial. Una, nais kong iklaro na ang salitang mini trial ay nanggaling kay Luis mismo sa mga interview sa kanya. Lalo nang isa nung naalala ko, interview niya kay Karen Davila. So, ito ngayon ang pahayag kanina ni Vice President Sara Duterte. Sabi, mga kababayan, Ang suliranin ng bayan ngayon ay ang nanganganib na pagsasara ng mga negosyo, ang pagkawala ng trabaho, at ang hirap ng bawat pamilyang Pilipino dulot ng patuloy na pagtaas ng presyo ng mga produkto. Ang imbitasyon na dumalo sa pagdinig ng Committee on Justice ay tila ginagamit upang makabuo ng isang media narrative o kwento na magkakaroon ng mini trial batay sa umano'y hindi pagsagot at hindi pagdalo. Sa ganitong paraan, ginagamit ang mga pagdinig upang makapagsagawa na naman ang House of Representatives ng ikatlong fishing expedition laban sa akin. Muli, inuuna ang politika kaysa kapakanan ng milyong-milyong Pilipino na hirap na dahil sa mahal na bilihin. Malinaw na walang patakaran na nagsasabing kailangang personal na dumalo ang respondent sa impeachment complaint sa mga pagdinig na Committee on Justice. Naisimiti ko na ang aking answer ad cautelaum. Sa ngayon, wala nang dapat pang gawin ang komite kundi ibasura ang mga reklamo dahil sa malinaw na kakulangan ng ebidensya. Samantala, mas pipiliin kong ilaan ang aking oras sa pagtulong sa mga Pilipino, lalo na sa pagbibigay ng paalaala diretso sa mga komunidad upang maibsan ang hirap sa gastusin ng pamilyang higit na nangangailangan. Vice President Sara Duterte.
Original motion of the Honorable
I'm-
Rodriguez.
I'm very concerned, Madam Chair, with the use of the word order, because I anticipate that the councils, based on what I read in this letter, it would appear that they are looking for reasons to question the committee before the courts. And if we
nga
use
malungkot,
that term, they can use it against us and say, see, you earlier you mentioned
Binibigyan pa ng pansin ito mga NPA na to.
trial. Now you are ordering us. And that will, then they can use that as a ground for questioning the committee. In fact, Madam Chair, they are entitled to their own opinion about what we are doing today. If they believe that we don't have jurisdiction, that's up to them. But I believe that we must just do our duty, fulfill what the Constitution commands, and hayaan na natin sila kung yan ang gusto nilang opinion. It's very clear from our discussion that we are not doing what they claim we are doing, that we are not going outside the jurisdiction, but rather following what the Constitution provides.
Chair, final point, Madam Chair.
To resolve the disparity between the motion of the Honorable Rodriguez and the suggestion of the Honorable Jokno, may we just release a letter in response to the letter of Fortuna Basa from the Justice Committee and not from the chairperson of the Justice Committee, if that would be acceptable to these two gentlemen.
First of all, just 2 points. First point, even in preliminary investigations, the prosecution orders clarificatory questions. Order does not mean that it will only come from the court or from the trial, the Senate, for example. Order is because we have jurisdiction. There is an order issued in preliminary investigation under the rules on criminal procedure that precisely order for there to appear to answer clarificatory questions by the prosecution. And so that fear of an order not being, it will cause some comments from the other party. It's not to me. It's not very at this point. It's not something that we cannot do. We have to therefore emphasize that as Committee on Justice is hearing. We are not having trials, but we are hearing for probable cause. And because they have sent this letter, which we find to be that they are not going to appear anymore because of no jurisdiction, an order requiring them to appear by stating also that their basis for not appearing, not recognizing the jurisdiction of this court has no basis in the Constitution, in law, and in fact. Thank you, Madam Chair.
I understand that the argument of Honorable Jokno is predicated from the fact that we're being framed to be conducting a trial, when in fact this is just a clarificatory hearing. So for purposes of caution, no, in order not to give them any opportunity to place us in a wrong impression of not following the Constitution and the rules, I don't see anything wrong about answering instead of issuing an order, if that will be acceptable to the Honorable Rodriguez.
Madam Chair,
The Committee on Justice can respond to the letter in its capacity as the committee and not me as the chairperson.
Madam Chair, I always agree with the chair. Thank you.
Madam Chair. Madam
Same
Chair.
manifestation, Madam Chair. We agree.
Madam Chair. Madam
The
Chair.
Honorable
Madam Chair.
Tino.
Well,
Madam,
sumasang-ayon po ako sa naging resolusyon dun sa
And that is the
particular-
letter of the Justice Committee.
Oo, particular dun sa hindi nagagamitin
Responding
ng...
point by point, the erroneous allegations in the letter for Tuner Basa.
Opo, na hindi nagagamitin yung salitang order, magpapadala ng sulat. Pero malinaw din po sa rules para lang i-put also on the record that the committee, according to the rules of procedure, that the committee shall have the power to issue compulsory processes for the attendance of witnesses and the production of documents and other related evidence. So just for the record, mayroon pa rin namang kapangyarihan
That is correct.
na mag-issue ng mga order, compulsory orders,
is correct.
ang committee ito. Yun lang po,
Just
Madam
because
Chair.
this is a formal proceeding, may I solicit the necessary motion pertaining to the answer
Chair.
which the committee will release in response to the Fortuner Basa letter.
Madam Chair,
Madam Chair.
I
Madam Chair.
defer to the position already expressed by the Honorable Chair with respect to just responding through a letter. But actually, my personal view is that we need not dignify that letter from the lawyer of
That's
the
another
respondent.
concern.
Yes, let's not dignify that. They're expressing their own position. It's not yet, it has to do, we can ignore that because it's wrong. It's erroneous. The position raised there is erroneous. And until and unless they really formally raise the matter, they formally raise the issue before this committee, then we need not rule on it. We need not issue anything. But I defer again. I defer to the position of the Honorable Chair and agreeing with the proposal of the Honorable Chair Jokno that we can only respond through a letter containing our arguments, our counter arguments on the position expressed in that letter. But as I said, we can actually ignore that and let's not dignify that. Thank
To
you.
finally resolve our proper action in relation to the letter of Fortuner Basa, may I hear the necessary motion on the letter which the Committee on Justice will issue? If you are not in favor to answering that letter, then perhaps you should not vote in favor of this motion. Because Honorable De Lima is now arguing that we should not dignify with an answer the letter containing erroneous allegations about the jurisdiction of the Justice Committee.
Madam Chair.
The Honorable
Yeah, Madam
Adjong.
Chair, I was earlier, I was actually eager to second the motion of Congressman Rufus Rodriguez. But upon hearing the observation and the recommendation of Congresswoman De Lima, I think that would be much proper because earlier, Madam Chair, I was actually explaining to the committee that we should not give them any chance of maybe, attributing we're on the same standing or the same footing because this hearing does not rely on the acknowledgement or recognition of the lawyers from the law firm. So I guess it would be proper, I think so, for my own humble opinion, that we should not, again, if I may also use the statements of Congressman De Lima, dignify, and instead exercise this committee's mandate because we also have the options to either making them order, as cited, pwede tayo mag-issue ng mga orders pala, as cited by Congressman Tino. So I think it would be much proper because we can still, maintain the integrity of this committee by simply not giving too much attention to their, to the position of this law firm. So
For
I
the guidance-
would suggest that we take consideration of the suggestion of Congresswoman De Lima not to dignify this letter.
For the guidance of the Justice members, our parliamentary status, there was a motion to issue an order. The same has been withdrawn by the proponent, the Honorable Rodriguez, by his conformity to the chairperson. Now there is a pending suggestion about issuing a letter from the committee to address the erroneous allegations in the letter of Fortuner Basa. But we are hearing another opinion not to dignify with an answer the erroneous allegations in the letter of Fortuner Basa. If there will be no motion, then it will be perceived and interpreted as no action will be taken to the answer of Fortuna Basa letter. Therefore, the chair announces that the
Madam Chair,
committee will not take any action to the letter. Let it be, so long as we are following the Constitution and the rules of impeachment of the House of Representatives. So ruled. Now we proceed to the next matter. Is
Madam
it
Chair.
about the letter?
Yes,
It has been
Madam,
ruled
about
upon
the
Vice
motion.
Chair Dumogan.
Thank you, Madam Chair.
We have a lot of things to discuss for today's hearing.
Well,
with
you have
your
already
indulgence.
ruled- You have already ruled, but I was about to suggest, because the most important is the tenor of our letter. This, we can say, this.
We are not issuing a letter because nobody moved
Yeah,
to issue a letter.
because there is some, despite your letter, we are inviting you to the next hearing. We can see it that way.
Nevertheless, the lawyers and the parties are always invited, notwithstanding the letters of non-appearance, notwithstanding the letter that they are not recognizing our jurisdiction.
My worry, Madam Chair, is if we do not also respond to that, they are directly attacking us. It's not, to me, it's not good. Why can we not just say, despite your accusation, we are respectfully inviting you to the next proceedings.
Madam Chair.
Vice Chair Dumogan, we take note of your manifestation, but this issue has been ruled upon. Now I proceed to the next matter for our today's
Madam
hearing.
Chair,
That
Madam
is the action. Is it about the letter?
Madam Chair,
Wait,
since
Honorable Marcoleta, is it about the letter? Because the same has been ruled upon.
ma'am, since the due process has been mentioned several times in today's hearing, I have something to say about it.
Is it
Due
about the
process.
letter?
Somehow somewhat related to the letter, but not confined to the letter. Let's not be confined to the. We're talking about due process, Madam.
All right, you are
If I may be allowed,
recognized.
just
For
2
the
points.
guidance of the members, our colleague is a non-member. Nonetheless, he is allowed to manifest. You may proceed.
Thank you, Madam. I respectfully rise for a brief manifestation for the record, Madam Chair. During the last hearing, I was advised by the Honorable Chair to peruse the rules because I raised the terminology sufficiency in grounds, which was mentioned, I think, 16 times by the Honorable Chair. And I have gone over the rules very diligently, and the rule provides that the committee shall determine whether the complaint alleges sufficient grounds for impeachment. Nowhere in the rules you can find sufficiency in ground. Ang aking pong opinion, Madam Chair, pag binago po natin o we alter the terminology, it will reap a different meaning or a different consequence. When we say we're just determining alleged sufficient grounds, we are just testing the allegations. Pag sinabi nating sufficiency in grounds, we seem to be weighing the evidence. So I just implore the wisdom of the Madam Chair to stick to the precise wording as stated in the rules. Yun lang, that's my number 1 point, ma'am. And
You have other manifestations?
yes, ma'am.
You may proceed.
Number 2, Madam, I have questions as to how the process of determining alleged sufficient grounds was achieved during the last hearing. How did we arrive at the determination? Because as far as I can recall, the Honorable Rufus Rodriguez suggested that we deliberate on the grounds, ground by ground. Because the complaints are nothing without the valid grounds from which its own merit should be anchored. So I agree with the view of the Honorable Rodriguez that we should have deliberated the two complaints ground by ground in order to arrive at a more judicious determination. And ang narinig ko lang po during the last hearing are perfunctory recital of allegations by the endorsers. So it would appear that this was just a peremptory declaration of sufficient grounds and nothing more. Yun lang po. Ang aking pong pakiwari, we should be not abbreviating due process because the ruling on Duterte versus House of Representatives stated that due process and the constitutional limitations should always be present at every stage of the impeachment process. That's all, Madam Chair. Thank
The
you.
committee notes all the manifestation of the Honorable Marcoleta. Now we proceed to our pending motions and or requests before the Justice Committee. The Honorable Joel Chua is recognized.
Thank you, Madam Chair. Madam Chair, the committee has received a letter dated March 5, 2026 on even date from Honorable Chel Jokno, where he moved that subpoena duces tecum be issued for the following. Number 1, duly certified copies of all the records of the NBI's investigation into the threats made by Vice President Sara Duterte against President Ferdinand Bongbong Romualdez Marcos Jr., First Lady Luis Lisa Cacho Araneta Marcos, former Speaker of the House, Ferdinand Martin Gomez Romualdez Sr., and certified true copies of all documents and photographs gathered in the course of the above-mentioned investigation. And number 2, duly certified true copies of the Statement of Assets and Liabilities and Net Worth of Vice President Sara Zimmerman Duterte for the years 2022 to 2025 inclusive, 2007 to 2013 inclusive, and 2016 to 2022 inclusive. Madam Chair, considering that the requested documents are relevant and material to the impeachment proceeding, I so move that subpoena duces tecum be issued pursuant to the letter dated March 5, 2026. So move, Madam Chair.
There is a motion to issue subpoena duces tecum to the NBI with respect to the records of its investigation into the threats made by Vice President Sara Z. Duterte against President Ferdinand Bongbong Marcos Jr., First Lady Marie-Louise Lisa Araneta, and former Speaker Ferdinand Martin Romualdez, as well as the certified copies, true copies of all documents and photographs gathered in the course of the above-mentioned investigation. Similar motion is made with respect to the certified true copies of the Statement of Assets and Liabilities and Net Worth, that is SALN, of Vice President Sara Zimmerman Duterte for the year 2022 to 2025 inclusive, 2007 to 2013 inclusive, and 2016 to 2022 inclusive. The second motion is directed to the Ombudsman. May I hear the confirmation of the Honorable Chua? For the SALN.
Yes, Your Honor.
The second subpoena is directed to the Ombudsman. That is with respect to the SALN of the Vice President. Do I hear a second? The same has been seconded. Is there any objection?
Madam Chair,
The Honorable Rodriguez.
we cannot
Are you objecting?
manifestation first before I would make my. We cannot have two motions being proposed at the same time. Practically, there should be two motions. The first motion are the NBI findings. The second is the SALN. We should go one by one, Madam Chair, because I am going to agree to vote yes to the first one. The second one, it is a fishing expedition. It is not. There are no ultimate facts on the SALN of the Vice President. So I will vote no I will object to the second one. The first one goes, Madam Chair.
May we
should
hear
divide-
from the,
we should have two motions instead of only one, two subject matters. Under our rules, in the rules of court, motions should only be on one subject matter.
Tama si Rufus Rodriguez.
may we hear from our proponent? The Honorable Rodriguez is suggesting that there should be one motion per subpoena.
Yes, I move that we vote
Would you like
on,
to amend your
yes,
motion?
I will amend my motion with respect to the, I move that we issue subpoena duces tecum to be issued to the, issued for the duly certified copies of all the records of the NBI's investigation into the threat made by the Vice President Sara Duterte against President Ferdinand Bongbong Marcos, and certified true copies of all documents and photographs gathered in the course of the above-mentioned investigation. And so move, Madam Chair.
There is a motion to issue a subpoena to the National Bureau of Investigation with respect to the records of investigation of threats made by the Vice President to the President, to First Lady, and to the former Speaker. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the motion is approved. The committee secretary is directed to issue the necessary subpoena. The Honorable Chua.
Madam Chair, with respect to the second subpoena, I move that we issue subpoena duces tecum to the Office of the Ombudsman for the issuance of the duly certified true copies of the Statement of Assets and Liabilities and Net Worths of the Vice President Sara Zimmerman Duterte for the years 2022 to 2025 inclusive, 2007 to 2013 inclusive, and 2016 to 2022 inclusive. So move, Madam Chair.
Binanggit pala ni Rufus Rodriguez na hindi siya bubuto sa ganong motion. Kasi po, ay hindi naman nabanggit yan sa reklamo laban kay Sara Duterte. So, fishing expedition. Na kahit dahil po hindi nabanggit. Pangalawa, bakit nila isama ang SALN mula noong 2007 hanggang 2016 o 2016 hanggang 2022, hindi naman Vice President pa si Sara nung panahon na yon. Inutos po ng Supreme Court sa pinakahuling labas ng desisyon nito sa kaso ni Duterte nung una, impeachment, sabi ng Supreme Court, hindi pwedeng isama sa kasong impeachment ang mga bagay na nagawa ni Sara noong hindi pa siya Vice President. So, tingnan natin po ang palitan kung paano mangyari nito kasi tinayuan po ni Congressman Rufus Rodriguez ng Cagayan de Oro na fishing expedition po ang nangyayari. Kung ipapasabpina ang SALN na hindi naman lamang nabanggit sa reklamo laban kay Sara.
There is a motion for issuance of subpoena to the Ombudsman with respect to the SALN of the Vice President from
Ngayon, kung fair ang mga congressmen, dapat hindi napayagan ito. Ngayon, kung papayagan na ito, isa na namang ebidensya ito na nag-abuso naman sila sa kanilang kapangyarihan. Kapangyarihan ng mga malitagang.
2022 to 2025, 2007 to 2013, 2016 to 2022. The same has been seconded. Is there any objection?
Madam Chair.
Is that an objection,
I
Honorable
object.
Rodriguez?
I object. This is now a clear fishing expedition against the Vice President. Thank you.
Considering that the motion has been objected to, we shall proceed to divide the House. Justice members, please be ready to vote. Those who are in favor of the motion for issuance of subpoena to the Ombudsman.
Dapat nagdebate muna kayo bago isumite sa voting. Tarantado talaga ito si Luis to. Para maintindihan ng lahat ng bumuto.
For the production of SALNs from 2022 to 2025, 2007 to 2013, and 2016 to 2022. Please raise your right hand.
Aba, mga malitagang bumuto, marami oh. Majority. Majority ng malitagang bumuto. Mga bubu o malitagang.
You may now put down your hands. Those who are not in favor of the motion, please raise your right hand.
Aba, isa lang.
You may put down your hand, Honorable Rodriguez. Those who abstain, please raise your right hand. That concludes the voting. Secretariat, the result, please. With 34 votes in the affirmative, 1 vote in the negative, and 0 abstention, the motion is granted. The committee is directed to issue subpoena duces tecum to the Ombudsman for the
Wala
production
na,
of...
ito ng unang kaso na isasampa ni Sara Duterte sa Supreme Court. Isasampa ito sigurado sa Supreme Court. Mali eh. Unang-una, bakit mali? Inyong batas po ninyo ay dapat ang ebidensya na ikukonsider ninyo ay yung nakasama lamang sa kaso na sinulat ng inyong nagreklamo. Hindi nga kasama yan eh. Invention na lang ni Ridon yan eh. Ay,
the SALN of the Vice President corresponding to the period of 2022 to 2025, 2007 to 2013, and 2016 to 2022. So ordered. The committee is likewise in receipt of the manifestation from the Honorable Congresswoman Laila De Lima. May we hear from the Honorable De Lima?
Thank you, Madam Chair. This representation confirms that as an ex-officio member of the Committee on Justice and as an endorser of the Sabalia et al. Complaint against Vice President Sara Duterte, I filed yesterday, March 24, with the Committee on Justice and with a copy furnished to respondent by the committee secretary, a request for the issuance of subpoena duces tecum and ad testificandum for the following 5 individuals, 5 resource persons and or witnesses. 1, Attorney Gloria A. Camora of the Intelligence and Confidential Funds Audit Office of the Commission on Audit to produce, identify, and authenticate official COA audit records, including liquidation reports, disbursement vouchers, certifications, and related submissions of the Office of the Vice President and the Department of Education pertaining to the disposition of the confidential funds for the years 2022 and 2023. In my letter, Madam Chair, there's a long list actually of those copies of those documents, the original copies of which we are seeking to be produced via subpoena from Attorney Gloria Camora of the Intelligence and Confidential Funds Audit Office of the Commission on Audit. I so move, Madam Chair, to issue subpoena duces tecum and ad testificandum to the named individual or named employee or official of the Commission on Audit.
There is a motion for the issuance of subpoena to Attorney Gloria A. Camora. You mentioned the Honorable De Lima, officials from COA. Other than
Attorney Gloria Camora.
Other than Attorney Camora, are there any other officials you would
Just
like to be
Attorney
subpoenaed?
Gloria Camora for the moment. Attorney Gloria Camora of the Intelligence and Confidential Funds Audit Office of the Commission on Audit because she's the custodian of these COA records and documents, including liquidation reports, disbursement vouchers, certifications, and related submissions of the Office of the Vice President and DepEd pertaining to confidential funds.
There is a motion for issuance of subpoena duces tecum and ad testificandum to Attorney Gloria A. Camora with respect as well to the documents pertaining to the confidential funds during the alleged period.
Yes, Madam Chair, as I said, it's a long list actually. There are the checks, the disbursement vouchers as listed, proof of submissions, liquidation reports, certifications, accomplishment reports, certifications of various dates, etc. It's a long list as listed in the letter of this representation, the letter request of this representation.
We are directing the committee secretary to provide copy of the manifestation or the request to the justice members. And the same is also adopted in support of the motion raised by the Honorable De Lima.
Madam Chair.
So ang motion nila ni Dilema ay ipadala ang records ng COA patungkol sa confidential fund. So ngayon, anong ang akin lang masasabi rito ay bawal din naman yan sapagkat hindi pa may kaso pa si Sara Duterte laban sa mga confidential fund receipts. At nag-apila pa siya. So, ibig sabihin po, sub judice or hindi na pwede i-preempt pangunahan ang COA na siya lamang ang may kapangyarihan na magsabi kung ang pagbibigay ng resibo ba ay tama o hindi, kung na paliwanag ba ni Sara o hindi ang mga gastusin. So, hindi nila pwede pangunahan ang Commission on Audit. At ngayon, lalo pat nakasampa na sa Supreme Court, hindi po nila pwede pangunahan. Yan lang po masasabi ko dito. Kaya tingnan natin ang kanilang action.
Discussion. I'd like to have a clarification.
Just for the record, the motion of the Honorable De Lima has been seconded by the Honorable
Yes,
Zamora.
now
Honorable
discussion.
Rodriguez.
I would like to clarify. Clarification from the proponent, from the movant. Is this the confidential funds of 2022 and then 2023 of the Office of the Vice President and not the Office of the Secretary of the Department of Education? Maybe clarify.
There are documents pertaining to the confidential funds of the Office of the Vice President, and there are also documents pertaining to the confidential funds for the Office of the DepEd, Department of Education.
Madam
Because
Chair.
those are grounds number 1 and 2 of the affidavit, of the complaint, the Sabalia et al. Complaint.
Madam Chair, when our distinguished Congresswoman De Lima, she mentioned of 22 and 23 years. In your first
23.
motion, when you stated the motion, 22, 23. So that's why I'm getting clarification. Are you now including the DepEd confidential funds?
There are
Because your
also
motion is 22 and 23.
22, 2023.
Because the COA has not been able to have a final notice of disallowance on the DepEd confidential funds.
Again, may I?
Yeah, because when I heard you, it was 2022, 2023. That is pertaining to the Office of the Vice President. But then now you're saying, in my clarification, that you are also moving for her to be able to give documents regarding the confidential funds of the Office of the Department of Education where she was secretary. Let us be clarified on that. Are
Yes,
you
yes,
also
Madam
including?
Chair. With respect to the DepEd, these are also, again, the list is here. With respect to DepEd, there will be accomplishment report dated September 30, 2023, for the period July 12 to September 30, 2023. So there's a covered period actually, 2022, 2023, and also it's 2023, and the certification issued January 1, 2024. Certification dated December 30, 2023. So covering also the Department of Education.
I would therefore object, Madam Chair, because it is this humble representation's position that under the Duterte versus House of Representatives ruling, only actions pertaining to the impeachable office of the impeachable official can only be the subject matter here. Objection, Mr. Chair, Madam Chair.
The Honorable Rodriguez is consistent
May I
in his
respond to
position
that
since our
objection?
determination of substance. The Honorable
Yes.
De Lima.
Well, that matter was settled already during the proceedings for the determination in substance and also for the proceedings for the determination of whether there are sufficient grounds for impeachment. At any rate, the Honorable Rufus Rodriguez made mention of the ruling of the Supreme Court in the SARA Duterte versus House of Representatives. And it says there, during the incumbency. Yes, it says there, during the incumbency of the impeachable official. Here, the Vice President. Now, it doesn't say in relation only to her office as Vice President. Because, you know, she was occupying the DepEd Secretary portfolio in her concurrent capacity as Vice President. Now, you don't distinguish the actions made, especially the anomalous actions, the impeachable offenses made because it's with the department, pertains to Department of Education. Just to explain it further, Madam Chair, what if the Vice President kills someone? It doesn't say it's in relation to or as Vice President and as DepEd Secretary, but that crime happens during her incumbency as Vice President. She may have two hands, as OVP, as VP, and as DepEd, but she has only one brain. She has one persona. She is the same person. Again, the Supreme Court says, during the incumbency of the impeachable official, but not in relation to. There's a big difference between that, the use of those phrases, during her incumbency and also in relation to her functions or duties as Vice President. So that is my counter-argument
With all due
to the
respect to
position
the
made.
Honorable De Lima and the Honorable Rodriguez, I believe that this issue has been deliberated upon amply during our determination of sufficiency in substance and even in the sufficiency in ground. So with the indulgence of all the members, let us proceed to vote on the motion for issuance of subpoena duces tecum and subpoena ad testificandum with respect to Attorney Gloria A. Camora and all the documents pertaining to the confidential fund in 2022 and 2023, both of the Department of Education and the Office of the Vice President. The same has been seconded. The motion was also objected to. Let us now proceed to vote. Members, please be ready to vote. Those who are in favor of the motion, please raise your right hand.
Aba, yung mga malitagang bumuto na naman.
You may put down your hands. Those who are not in favor of the motion, please raise your right hand.
Si Rufus
You may
Rodriguez
put
na.
down your hand, Honorable Rodriguez. Those who abstain, please raise your right hand. That concludes the voting. Committee Secretariat, result please.
Mga malitagang. So ngayon, nais ko lang din sasabihin na mali, unang mali nila yung SALN sapagkat hindi po siya kasama sa sinulat na reklamo. Kaya hindi po pwede yun sa batas. So ngayon, pangalawang motion, yung nauna sa NBI, okay yun. Pangalawang motion na inaiwan kinontra ni Rufus Rodriguez ay yung mga records ng PUWA, Commission on Audit. Kinontra ni Rufus Rodriguez pero natalo siya sa boto, siya lang mag-isa. Oh, habang nagbubutuhan pa sila, nagbibilang, magkwentuhan tayo. So,
With 29 votes in the affirmative, 1 vote in the negative, and 0 abstention.
kanina,
The motion is granted.
ngayon 29 na.
The committee is directed to issue the necessary subpoena, duces tecum, and subpoena ad testificandum to Attorney Gloria A. Camora, and with respect as well to the production of pertinent documents on confidential fund of both the DepEd and the Office of the Vice President in 2022 and 2023. So ruled. Honorable Dilima.
My second motion is to issue subpoena duces tecum and ad testificandum to Mr. Ramil Lagunoy Madriyaga.
Ito naman si Ramil Magunoy. Sige, tingnan natin. So, dalawang ground na si Sara Duterte na gamitin pupunta sa Supreme Court. Ngayon, pangatlo nito, Ramil Madriyaga na naman.
Produce, identify, and authenticate his
Alam mo, nais ko lang bagitin, ang nag-motion pala si Dilema pa. Hindi ka ba nahiya, Dilema? O, kaibigan ka na, idol ka ni Ben Marhuerte. Tsaka ni Ben Reclamador. Hindi ka ba nahiya? Nung ikaw ay kinasuhan sa panahon ni Duterte, na mga tauhan ni Duterte, nagreklamo ka kasi preso ang ginamit na testigo laban sa iyo. Ngayon, ikaw magbubosyon na gagamiting testigo ang nakabilanggo na si Ramil Madriyaga. Ano klase? Asan ang iyong fairness? Lila Caballo Dilema?
affidavit dated November 29, 2025, which is Annex A of the complaint in the Sabalia et al. Complaint, and any other documentary or object evidence in his possession, and to testify thereon.
Saan si
This is
Junel?
with respect to receipt on the receipt, handling, and distribution of the confidential funds.
Junel!
It's very clearly alleged in the complaint of the Sabalia et al.
There is a motion
Junel!
raised by the Honorable Dilima to issue subpoena duces tecum and subpoena ad testificandum to Ramil Lagunoy Madriyaga, and for the production of affidavit dated November 29, 2025, as well as any other evidence in his possession. The same has been seconded by Vice Chair Dumogan. Is there any objection?
Madam Chair, objection because again, there is a
Carry the
statement
motion,
here
Laila
in the
Maleta.
third column that it's also his testimony on the DepEd's confidential funds where we have no jurisdiction. Objection, Madam Chair.
Considering that the motion has been objected to, we shall now proceed to vote. Committee on Justice members, please be ready to vote. This is on the motion for the issuance of subpoena duces tecum and subpoena ad testificandum to Ramil Madriyaga, as well as for the production of his affidavit and any other evidence in his possession. Those who are in favor of the motion, please raise your right hand. You may put down your hands. Those who are not in favor of the motion, please raise your right hand. Thank you, Honorable Rodriguez. Those who abstain, please raise your right hand. That concludes the voting. Committee Secretariat, result, please.
Asahan mo pa yan? Puro mga maleta gang. Laila Maleta. Dilema.
With 29 votes in the affirmative, 1 vote in the negative, and 0 abstention.
Patay.
The motion is hereby granted.
Pangat.
The Committee on Justice is directed to issue the necessary subpoena duces tecum and subpoena ad testificandum to Ramil Madriyaga and for the production of his affidavit dated November 29, 2025 and any other evidence in his possession. So ruled.
Napakaklaro po na walang laman, walang kalaman-laman ang affidavit ng Madriyaga na yun. Pinipilit nyo pa rin. Well, nasa inyong choice yan. So ngayon po, makikita na ninyo kung ano ang nangyari ngayon. Ano pa ba?
Honorable Dilima.
My third motion is for the issuance as well of subpoena judice tecum and ad testificandum to Attorney Cynthia Viñas Pantonal, the notary public who notarized the affidavit of Mr. Madriyaga, to identify and authenticate the due execution and notarization of Mr. Madriyaga's affidavit. I so
Second,
move.
Madam Chair.
There is a motion to issue subpoena duces tecum and subpoena ad testificandum to Attorney Cynthia Viñas Pantonal, as well as for the production of the original copy of the affidavit of Mr. Madriyaga dated November 29, 2025. Do I hear a second?
Second,
The same
Madam
has been
Chair.
seconded. Is there any objection?
Madam Chair, objection.
The same objection is
consistent.
registered by the Honorable Rodriguez. Let us proceed to vote. Justice members, those who are in favor of the motion, please raise your right hand. You may put down your hands. Those who are not in favor of the motion, please raise your right hand. You may put down your hand, Honorable Rodriguez. Those who abstain, please raise your right hand. That concludes the voting.
Madam Chair, I just stepped out, but I'm voting in favor of the motion as
The
well.
Honorable Jokno is registering his vote in favor of the motion. Result, please. With 30 votes in the affirmative, 1 vote in the negative, and 0 abstention, the motion is granted. The committee is directed to issue the necessary subpoena duces tecum and subpoena ad testificandum to Attorney Cynthia Viñas Pantonal, as well as the production of the original affidavit of Mr. Madriyaga, executed on November 29, 2025. So ruled. The Honorable Dilima.
Madam Chair, my fourth motion is also for the production of subpoena judice tecum and subpoena ad testificandum to the custodian of the Archives Division of the House of Representatives to produce, identify, and authenticate transcripts, video recordings, and related records of prior hearings of the House Committee on Good Government and Public Accountability on the Office of the Vice Presidents and Department of Education's disposition of their confidential funds for 2022 and 2023. I so move, Madam Chair.
There is a pending motion for
Talagang walang mangyari sa buhay ni Sara dito. Lahat sila po ay nakamaleta na.
the issuance of subpoena duces tecum and ad testificandum to the Legislative Library Archives Division, House of Representatives, as well as for the production of transcript and video recording of the House Committee on Good Government and Public Accountability on September 18, 2024, September 25, 2024, October 17, 2024, November 5, 2024, November 25, 2024, as well as the production of the affidavit of USEC Gloria Mercado and the envelopes labeled Hope submitted by Undersecretary Mercado. The motion has been seconded by the Honorable Zamora. Is there any objection? Hearing none, the motion is hereby granted. The necessary subpoena duces tecum and ad testificandum in as far as the Legislative Library Archives Division of the House of Representatives is hereby directed to be issued by the committee. The Honorable Dilima.
Madam Chair, the fifth and last motion
Laila
for
Maleta.
today's proceedings
Meron pa
for the
pahabol.
production of subpoena juris tecum and subpoena ad testificandum to be addressed to a representative from the Philippine Statistics Authority to produce, identify, and authenticate certifications from the civil registry system, such as the database, the PSA Civil Registry System database on the certificate of live birth, certificate of marriage, certificate of death on several names found in the submissions of the Office of the Vice President and Department of Education, particularly certification dated December 8, 2024 and December 11, 2024. This is to show the recipients of OVPs and DepEd's confidential funds had no birth, marriage, or death records, as well as to identify and authenticate the requested certifications. I so move.
There is a motion for issuance of subpoena ad testificandum to the Philippine Statistics Authority, Carlos P. Garcia, to the Philippine Statistics Authority, or to the representative of the Philippine Statistics Authority, and for subpoena duces tecum with respect to the original copies of the certifications pertaining to PSA verification made from PSA Civil Registry System database on the certificate of live birth, marriage, and death on several names found in the submissions of the OVP and DepEd, particularly the following: certification dated December 8, 2024, and certification dated December 11, 2024. Do I hear a second? The same has been seconded. Is there any objection? Hearing none, the motion is granted. The committee is
Chair.
directed to issue the necessary subpoena to the representative of the PSA, as well as for the production of the documents mentioned therein.
Madam Chair, just a manifestation.
The Honorable Marcoleta is recognized.
Thank you, Madam Chair. I recall during the previous hearings, maybe 2 or 3 past hearings ago, I raised the issue of procedural due process when I said that ginanap ng Kongreso ang trabaho na di dapat nila ginagawa dahil ito ay trabaho ng COA. And I was referring to the past hearings made by the Quadcom, or if I'm not mistaken, the Committee on Good Governance. And the chair remarked that wala pong kinalaman ang mga past hearings ngayong hearing ng impeachment ni BP Sara. Pero ngayon po ay tila ginagamit natin at humihingi tayo ng dokumento mula sa mga hearings na yon. So ako po ay nagugulumihanan. Kala ko po ba walang kinalaman ang mga past hearings ng Quadcom o ng Committee on Good Government, pero tayo po ay nagbabalik tanaw at kukuha ng mga dokumento mula sa archives ng hearing na yon. May I be clarified, Madam Chair?
This impeachment proceeding pertains to the fitness to hold public office of our Vice President, Sara Zimmerman C. Duterte. That is the reason why manifestations pertaining to the past inquiry of Quadcom and even of the Committee on Good Government was discouraged by the chairperson. Nevertheless, all the manifestations of the Honorable Marcoleta are duly noted by the Committee on Justice. Now we proceed. We have discussed already all the pending matters before the committee, and the chair wishes to reiterate the previously announced schedules for our subsequent hearings. That includes April 14, after this announcement, April 14, April 22, and April 29.
Madam Chair.
The Honorable Tino first, and then the Honorable D.S. Conghon.
Madam Chair, may I make an additional motion for the issuance of a subpoena?
Like to make another motion for the
Yes.
issuance of subpoena.
I move that the subpoena be issued to Attorney Michael Wesley Poa in his capacity as the former Chief of Staff of the Vice President and DepEd Secretary from 2022 to 2023. In such capacity, he has very material and relevant information on how the confidential funds in the DepEd were used, and in particular, he had a direct role in the preparation of the accomplishment reports relating to the use of the DepEd's confidential funds, some of which these accomplishment reports have been the subject of the request for subpoena that this committee has approved.
Napakabobo naman to si Congressman Tenyo. May lawyer-client relationship eh. Hindi mo pwede isasama yon. At saka may ibang tao naman nagtatrabaho nun, hindi naman trabaho ni PUWA yun.
May
So
we
I
hear
so
from
move, Madam
our
Chair.
endorser? Would you like to comment to the motion of the Honorable Tino? He wishes for the issuance of
Another
subpoena ad
PC
testificandum to
expedition
Attorney
naman.
Michael Poa, considering that during that time, he was assuming the position of
Chief of Staff of the DepEd Secretary.
COS
Yes.
of DepEd.
Undersecretary, with the rank of Undersecretary.
At saka
Honorable
DepEd
Dilima?
yun.
My
Hindi
motion
yan
was
Office of the Vice President. O DepEd yun, hindi yung Office of the Vice President. Kabubuhan.
pertained only to the custodian of those COA audit records, including liquidation reports, disbursement vouchers, certifications, and related submissions from the custodian, the official custodian of the Intelligence and Confidential Funds Audit Office of the Commission on Audit. I won't have any strong objection to that request, since it's related to this item.
All right,
The
so
subject matter of the first motion that I put forth, which was approved by the body.
the
Thank you.
chair will now act on the motion. The
Ala,
committee
sir,
will now
sa-
act on the motion.
Karihan nyo.
Is that an objection to the motion of the
Definitely.
Honorable Tino?
I object.
Yeah.
Are there documents
2,000.
that the Chief of Staff, Attorney Poa, has signed that he would be a witness to identify? May I ask the proponent?
Before we entertain the objection of the Honorable Rodriguez, let me just formalize that there is a motion raised by the Honorable Tino to issue a subpoena ad testificandum to Attorney Michael Poa, considering that he was the Chief of Staff of the Office of the Department of Education during the alleged period of 2022 and 2023. Do I hear a second?
Second.
The same has been seconded by the Honorable D.S. Konghon. Now let's hear the objection of the Honorable Rodriguez.
Madam Chair, I could not find nexus borne by evidence or ultimate facts that would now make the Chief of Staff and lawyer
Diyan na siya,
of the Vice President to be subpoenaed. In fact, he has entered this appearance as counsel. So I would like to know whether there are documents which he certified or he signed that would make him be able to be invited to be given subpoena to appear in this committee. Otherwise, then we can, just because they are in the office of the Vice President, we'll be giving subpoena to everybody there in the Vice President's office. So I object, and I would like to know about that. Are there documents that would show that he has been part of these confidential funds?
Yes, Madam Chair, in the third complaint endorsed by the Honorable Dilima, there is a section extensively discussing the role that then USEC POA played in preparing the accomplishment reports pertaining to the use of the confidential funds, where and the complaint cites the transcripts of the hearings of the Committee on Good Governance on this matter, where USEC POA admits that he was ordered by the Vice President to submit these accomplishment reports, and also cited in the complaint that the several Army units denied what was claimed in these accomplishment reports.
with
Justification. Continue with justification in the objection of the Honorable Rodriguez. We are a collegial body, so we shall now proceed to vote on the motion
Before
of the
the
Honorable
voting,
T.
Madam Chair, I would like the proponent to show to us documents, certifications that had led to the release of these confidential funds. Because we are now already on the hearing, precisely.
wala siya
Are there any? Because if there's none, there is no reason to call him and subpoena a lawyer.
Madam
The
Chair,
Honorable
as I
Tino.
said, I cite the complaint itself, the third
Alam mo, pag inaprubahan nila ito, dito na sila ngayon matatalo sa Supreme Court kasi galit na galit ang Supreme Court kapag ilabagin mo yung pagiging abogado. Ang pagiging abogado po ng isang tao ay hindi po yon hindi pwede labagin kasi may tinatag na secrecy sa between lawyer and client. Ngayon, para malaman mo kung sakop ng secrecy ng lawyer-client, ipakita ng dokumento. Kaya nga hinihingi ni Rufus Rodriguez. Ang problema sa inyo, mga bubo kayo, galit lang kayo kay Sara, pagpipilitan ninyo ng abogado niya, ay pinapasalitain laban kay Sara. Tarantado. Yan po si Tinyo na NPA. Sige. NPA.
complaint.
Allegations lang naman yun, wala nga dokumentado.
Specifically, starting from
The process of utilization of the alleged confidential funds is not confined to the documents.
okay.
There could be actions that contributed to the utilization of confidential fund, which might be covered by the testimony of the possible witnesses.
Okay. Well, starting from paragraph 269 of the third complaint, page 90, there is a reference to former DepEd spokesperson. He was spokesperson as well as chief of staff, Michael Poa, testifying that he received envelopes directly from Vice President Sara herself. So this has to do with the allegation on bribery. And further, and there are other sections as well pertaining to the use of the confidential funds, Madam Chair. If Congressman Rodriguez would want, we can provide, given enough time, Madam Chair.
Madam Chair, we are now voting, so we should be able to get it if there is. The fact that he's chief of staff and counsel will not, implicate him to be able to have that if there is no document. So I would object to that, Madam Chair.
With the indulgence of these two gentlemen, as to whether or not there's relevance in the presentation of Attorney Michael Poa, will be a question that rests on the judgment of the justice members. We shall now proceed to vote. Those who are in favor of the motion for issuance of subpoena ad testificandum to Attorney Michael Poa, please raise your right hand.
Ito na ngayon, ang pagboto-boto ninyo, ito na ngayon ang magiging armas nila ni Sara Duterte na immediately ay actionan ng Supreme Court.
You may put down your hands. Those who are not in favor of the motion,
At sigurado ako na actionan ng Supreme Court.
thank you, Honorable Rodriguez. 2, 3. Were you able to count? Those who abstain, please raise your right hand.
Naging si J.J. Suarez, unggoy talaga. Oh.
That concludes the voting. We shall announce the result. With 34 votes in the affirmative, 3 votes in the negative, and 0 abstention. The motion is granted. The committee is directed to issue the necessary subpoena ad testificandum to Attorney Michael Poa. So ruled.
Madam Chair,
The Honorable Jokno.
there's still one more pending incident, I believe, that pertains to the petition that this representation filed with the House, which was referred last Wednesday to the committee. This is a petition under Section 8 of the Rules on Impeachment, which provides that the House may, upon proper petition, provide adequate protection to a complainant or witness if it is shown that the personal safety of the witness is in jeopardy because of participating in the impeachment proceeding. I will no longer reiterate what is contained in my petition, Madam Chair, but if I may just add a few points that I believe are important for the consideration of the committee. Una-una po, para sa kaalaman ng taong bayan, hiniling natin ang proteksyon para kay Ramil Madriaga para makapunta siya rito at magbigay ng kanyang testimonya under oath sa harap ng committee ito. Standard po ito sa sino mang saksi, pero mas mahalaga ito dahil may mga direktang ulat na galing mismo kay Ginoong Madriaga na may panganib sa kanyang buhay. In his own sinumpaang salaysay, sinabi niya, and I quote, "Araw-araw na rin nagsasabi sa akin, delikado na talaga ang buhay mo, seryoso. Ingat Ram, balita ko mataas-taas ang reward money sa iyo. Secure mo ang family mo at iba pa." Sa loob ko ay nakakaramdam ako ng sobrang takot. Ang takot na yon ay hindi lang sa sarili ko, kundi pati sa aking pamilya. Napaparanoid na rin po ako kasi posible rin itong mangyari, nalasunin ako. Halos hindi na ako mapakali, kuminsan at hindi ko maiwasan magduda na rin sa mga fellow PDLs at kahit po mismo sa mga jail officers dahil sa pagsiwalat ko ng issue kay VP Sara Duterte. Madam Chair, these threats have already escalated. According to his affidavit, on March 3, 2026, a detainee with a pending homicide case attempted to forcibly drag Mr. Madriaga into a confined bodega area within the jail. According to Mr. Madriaga, and I quote, "Ayon sa mga naririnig ko sa loob ng kulungan, ang bodegang ito ay sinasabing pinagawa ni dating Congressman Arnie Teves. Isa sa mga impormasyon na nakuha ko ay si Kong Arnie Teves ang gusto magpatumba sa akin," end quotation. Kinumpirma naman po ni DILG Secretary John Vic Remulla na binisita ni Vice Presidente si dating Congressman Teves sa kulungan noong October 19, 2025. Base ito sa ulat ng Inquirer na mismo ang Vice President ang nag-attach sa kanyang perjury complaint laban kay Ginoong Madriaga. Ito ay matatagpuan mismo sa Annex V sa complaint affidavit na minarkahang Annex 5 sa Consolidated Verified Answer ad cautelam ni Vice President Sara Duterte. Just to be clear, this is not intended to accuse anyone. I'm merely raising a concern in our quest to find the truth. If we allow a witness to be intimidated, hurt, or God forbid, killed, then we fail in our constitutional mandate. In terms of what kind of adequate protection I believe would be necessary, I believe that would entail three things, Madam Chair. Number one, that the security for the witness be beefed up, particularly by the National Bureau of Investigation. Second, that his attendance when he is required to appear here be done in a secure manner, that there is sufficient security for his transport here, and also while he is here to testify, that he be put in a secure place. Thank you, Madam Chair.
Ito yung klaseng itong tao, si Chilyok, no? Wala siya sa tatay niya kay si Jok, no? Napakabubo na abogado. Ay.
Would you like to raise the necessary motion with respect to the protective custody of witness Ramil Madriaga?
Yes,
Wala, gawin nyo ng gusto nyo gawin habang kayo pang nasa poder.
Madam Chair, in line with Section 8 of the Rules of the House on Impeachment, I move that adequate protection be provided to Mr. Ramil Madriyaga, consisting of three things. Number one, that the security where he is presently detained be beefed up, particularly by the National Bureau of Investigation. Number two, that his attendance, when required by the committee, be secured as well, so that his safety will be, so that his life will not be put in danger. And number three, that while he is testifying before this committee, that again, proper safeguards be put in place to ensure his that his life will not be endangered. I so move, Madam Chair.
So for
Second.
clarification, the Honorable Jokno, you are requesting, in line with protective custody, is to augment the current security with the NBI security.
Yes, Madam Chair.
You are also requested for sufficient security during his transport to the hearing of the Justice Committee.
And
And you
he
also
is
requested
testifying.
for a secured and safe place for his confinement
While he is testifying. Yes,
while he is
Madam Chair.
testifying before the Justice Committee. So we've heard the details of the protective custody which are being requested by the Honorable Jokno by way of his motion. There is a motion to formalize the same. There's a motion for protective custody of witness Ramil Madriyaga, consisting of augmented security by the NBI, security during transport to hearings of the Justice Committee, and secured place of confinement during the hearing as well of this committee. Do I hear a second?
I second the
Madam Chair,
motion.
The same has been seconded.
Madam Chair.
point of
May we know the pleasure of the Honorable Rodriguez? Are
Madam
you-
Chair, I would like to know whether directly whether the motion would transfer custody of Mr. Madriyaga to the House of Representatives premises.
May we be clarified on that, the Honorable Jokno?
I did not include that in my motion, Madam Chair.
I understand that the motion is only to make sure that he is in a secured place of confinement.
Yes. Madam Chair, it has already been stated that the Honorable Director of NBI has already assigned personnel to watch 24 hours. Mr. Madriyaga in Camp Bagondiwa. In fact, the jail superintendent has already stated that Madriyaga has been transferred to a solitary cell so that there'll be no other people there that will endanger his life. And so, Madam Chair, with the presumption, Madam Chair, of regularity of functions and that our witnesses will be fully protected, there's no need for this motion. Secondly, Madam Chair, Ramil Madriyaga is a polluted source. He is facing kidnapping with murder charges. In 2021, one member of the anti-kidnapping gang was killed. The PNP member of the anti-kidnapping gang. And then they were arrested in 2022, 2023. That's why he is in jail. And now we're going to give credence to a
Madam
polluted
Chair.
affidavit.
Point
Madam
of order.
Chair, no,
There is
Madam
a
Chair.
point of order,
Let us clarify,
Honorable
we're trying to
Rodriguez.
protect somebody who's a polluted source. In fact, in
Madam
the
Chair.
cases of the
Honorable
Supreme Court,
Rodriguez, there's a point of order.
thank you, Madam Chair.
Let's hear the point of
Premature.
order. The Honorable De
Madam
Lima is
Chair, I
recognized.
submit that it's clearly premature for anyone to raise an issue of credibility on the part of the intended witness. He's not.
Ikaw nga, Dilema. Laila Maleta Dilema. Laila M. Dilema. Laila Maleta Dilema. Di ba? Kinaswang ka, nagreklamo ka, ang mga testigo laban sa'yo, puro mga preso. Ay, Junel, saan ka na, Junel? Oh. Si JB Sebastian, testigo laban sa'yo. Sino pang iba? Si Kulangko. Nagreklamo ka nga. Ngayon, ang gagamitin mo, testigo para sa ibang tao, laban sa ibang tao. Gamitin mo, preso na sentensyado ng kamatayan na ilabas lang ng Supreme Court dahil may teknikalidad sa kanyang kaso na sentensyan sa kidnapping. Ngayon, may kasong bagong kidnapping na kung saan ang kidnap nila ay yung mga dalawang Chinese na kanilang kliyente na sila ang magbabantay tapos sila pa nagkidnap, bantay sa lakay. Ay nako, tinuro na ng mga biktima si Ramil Madriyaga na isa sa kumidnap sa kanya. Hayaan mo yung korte mo na magdesisyon diyan. Ngayon bibigyan niya pa ng bibigyan pa ninyo gagamitin niya testimonya na kulang-kulang, walang detalye. Ay nako, dilema ka talaga.
Testifying. He will testify, and therefore, issues of credibility can be raised in the questioning, in the clarificatory questioning. Mr. Madriyaga can be asked about those things during the hearing, the proper stage of the hearing, but not at this point. So it's out of order. Any such statement relating to the issue of credibility, statements like a polluted source, that is not yet proper at this stage of the proceedings.
Would you
Madam
like to
Chair.
raise a motion concerning the manifestations of the Honorable Rodriguez with respect to the credibility of Ramil Madriyaga?
I move that that particular part of the manifestation of the Honorable Congressman Rufus Rodriguez with respect to Mr. Madriyaga being allegedly a polluted source and the related statements with respect to the issue of his credibility be stricken off the records.
Is there any second?
Second, Madam
The
Chair.
same has
Madam
been
Chair.
seconded. Is there any
I
objection?
will, yes, of course, Madam Chair, because we are
Two
trying
two
to...
motions are pending now.
Yes.
One is the motion for the issuance of subpoena motion for protective custody of Ramil Madriyaga, raised by the Honorable Chel Jokno, and second is the motion to strike off from the record the manifestation concerning the credibility of Ramil Madriyaga. The same has been seconded as well.
This presentation is not out of order. We are discussing about giving a bundle of rights, 3. All of this to be able to give that advantage, that perceived, safety issues which are not. That's why me stating that to give this bundle of rights, to give this protection, to all of this custody and so forth in a safe place, should not be given to a polluted source. That is the point that I have. And therefore, it is not out of order. We are discussing, we are objecting to this particular motion. And that is the reason why, these are the reasons why I say that we have to know this person whom we are giving all of these extra advantages and extra attention and care which he does not deserve.
Madam Chair,
The Honorable Dilima.
Mr. Madriyaga is listed as one of the witnesses for the
Tangina mo.
complainants. And that's why I asked for the issuance of subpoena juris tecum.
Okay
It
lang
is very
yan.
clear under Section 8 of the Rules of Procedure in Impeachment Proceedings, protection to complainants or witnesses. The House may, upon proper petition, provide adequate protection to a complainant or witness if it is shown that the personal safety of the complainant or witness is in jeopardy because of participating in the impeachment proceedings. And we have heard the manifestation and the explanation of the Honorable Chel Jokno about the alleged threat to his safety. And therefore, it is very much in order that we tackle the issue of grant of protection in the mode that was described and asked or sought for by Congressman Chel Jokno, and the motion has been duly seconded. Thank you.
We've heard amply the argument of both the Honorable Rodriguez and the Honorable Dilima. For the guidance of the Justice members, our parliamentary status is there's a pending motion by Congressman Chel Jokno for protective custody of witness Ramil Madriyaga. The same has been seconded. The same is objected to by the Honorable Rodriguez. There's likewise a pending motion by the Honorable Laila Dilima to strike out from the record the manifestation of the Honorable Rodriguez pertaining to the credibility of witness Ramil Madriyaga. The same has been seconded as well, and the same was objected to as well by the Honorable Rodriguez. We shall now proceed to divide the House, starting with the first motion. That is the motion of the Honorable Chel Jokno. Again, for the guidance of the members, the motion is for the protective custody of Ramil Madriyaga. Those who are in favor of the motion, please raise your
Madam
right
Chair,
hand.
may I just clarify
Yes, please.
that my motion requests, I'm moving specifically for 3 things. Number
Yes.
1, that we make sure that there is additional security provided to Mr. Madriyaga
You said from the NBI.
in his present place of detention by the NBI. Second, that both in the transport when he is required to come here to testify and while he is testifying, again, that adequate security be provided to him.
All right. So those who are in favor of the motion for protective custody of witness Ramil Madriyaga, please raise your right hand. You may put down your hands. Those who are not in favor, please raise your right hand. Honorable Tino. Thank you, Honorable Rodriguez. Those who abstain, please raise your right hand. That concludes the voting. We shall announce the result. With 35 votes in the affirmative and 1 vote in the negative, with 0 abstention, the motion is granted. The Secretariat is requested to closely coordinate with the Office of the Sergeant at Arms and/or Legislative Security Bureau for the protection of Ramil Madriyaga. As courtesy by the committee, please also notify the BJMP as well as the respective regional trial court which ordered his detention. So ruled. Indeed, all the pending matters were already addressed by the committee. The chair believes that we should...
Madam Chair.
The chair stands corrected. There's another pending motion from the Honorable De Lima. May we request the Honorable De Lima to restate the motion?
Yes, Madam Chair. I move that the portion of the statement or manifestation of the Honorable Rufus Rodriguez attacking the credibility of the intended witness, Ramil Madriyaga, the issue of his credibility, those allegations about...
Dilema. Nung kinasuhan ka, puro mga preso ang ginamit na testigo laban sa'yo, kontra ka ng kontra kasi mga preso. Ngayon, preso na rin ang ginagamit, depensahan mo. Anong klaseng tao ka? Laila Maleta Dilema.
being a polluted source, Ramil Madriyaga being a polluted source, be stricken off from the records.
There is a motion to strike out from the record the manifestation of the Honorable Rodriguez with respect to the credibility of witness Ramil Madriyaga. Do I hear a second? The same has been seconded. Is there any objection? There is an objection. Let's proceed to divide the House. Those who are in favor of the motion, please raise your right hand.
Laila Magistrado Dilema. Laila Maleta Dilema. Ikita nyo? Gusto nyo pa atin si Sara Duterte dito? Tingnan mo, mga NPA bumuboto kontra sa kanya. Tawa pa ng tawa.
You may put down your hands. Those who are not in favor, please raise your right hand. Thank you, Honorable Rodriguez. Those who abstain, please raise your right hand.
Grabe sila Rapino at si Rufus Rodriguez. Kahit nag-iisa na lang siya, pinaglalaban niya yung pagiging abogado niya.
That concludes our voting. We shall announce the result. With 34 in the affirmative, 1 in the negative, and 0 abstention. The motion is granted. The committee secretariat is directed to strike out from the record all the manifestations of the Honorable Rodriguez pertaining to the credibility of witness Ramil Madriyaga. So ruled.
Madam Chair.
We have concluded all the pending matters before the committee, and we shall now proceed to the determination of
Madam Chair.
the Honorable Ridon.
I wanted to return again to the matter of SALN and unexplained wealth. I understand that Congressman Chua had already moved for the subpoena of the SALNs of the Vice President, and I will also be moving for the following documents and for the committee to issue subpoena duces tecum and ad testificandum on the following. A representative from the Bureau of Internal Revenue to bring the following: tax compliance and reported income of Vice President Sara Duterte, her spouse, Attorney Manasseh Carpio, and various business entities in which they hold interest. Original or certified true copies of the annual income tax returns and other relevant documents pertinent thereto, such as
Kaya mo, wala, hindi nakasama sa reklamo yan. Pinapakwa ni Tere Ridon, no? Yung pisngi mo, sobrang taba. Anong kinakain mo? Mr. Bean, cookie.
VAT payments of Vice President Sara Duterte,
Ay, mahiya naman kayo mga Bicolano. Bakit binoto nito Bicol Saro na to?
spouse Manasseh Carpio for the years 2007 to 2025, and the following entities for the periods specified: Metro City Chow Foods Corp., formerly City Hall King Chow Foods Corp., for the years 2007 onwards; Gen Corp Industries Inc., formerly Times Square B Foods Corp., and Great Jolly Times Food for the years 2021 onwards;
Dami palang negosyo ni Sara.
Carpio Lawyers, formerly Carpio Duterte, for the years 2007 onwards; 888 Bistro,
Ika mo na hindi mo pwede mapasampina ang law firm. Bakit? Kasi ang law firm, kahit sinong law firm, may mga kliyente. At kung may mga kliyente, hawak nila pati sakop po ng lawyer-client relationship secrecy rule ang mga perang binayad nila sa lawyer nila. Kaya hindi mo pwedeng i-inquire kung magkano kinita ng law firm. Mr. Ridon, abogado kang pulpol, gumraduate ka ba sa UP College of Law?
for the years 2021 onwards; Kale 88 Foods Corp. for the years 2021 onwards; Madayo Fisheries Corp. for the years 2021 onwards; Mati City Ice Plant and Cold Storage Inc. for the years 2023 onwards; Amianan Shores Inc. for the years 2023 onwards; Geometry Security and Investigation Agency Inc. for the years 2023 onwards; and Cable Tow 88 Shipping and Marine Services Inc. for the years 2024 onwards. So moved, Madam Chair.
There is a motion for the issuance of subpoena ad testificandum to the
Basic expedition, hindi ka nakasulat sa reklamo laban kay Sara. Tapos bubuksan nyo.
BIR representative and for subpoena duces tecum to the aforementioned documents by the Honorable Ridon. Do I hear a second? Any second to the motion of the Honorable Ridon?
Second.
The same has been seconded by the Honorable Dolima. Is there any objection? The Honorable Rodriguez is registering his objection. If you have no other manifestation, we shall proceed to vote. Those who are in favor of the motion, please raise your right hand. You may put down your hands. Those who are not in favor of the motion, kindly raise your right hand. Thank you, Honorable Rodriguez. Those who Thank you. Thank you, Honorable Keith. Those who abstain, please raise your right hand. That concludes our voting. We shall announce the result of voting on this motion. With 34 votes in the affirmative, 2 in the negative, and 0 abstention. The motion is granted. The chair directs the committee secretariat to issue the necessary subpoena ad testificandum to the BIR representative and subpoena duces tecum with respect to the ITR of VP Sara Duterte,
Sabi ng kapatid ko, para makarubot kayo.
her spouse Manasseh Carpio for the year 2007 to 2025, including the entities for the same period as mentioned by the Honorable Ridon. So ruled. Honorable Ridon.
Madam Chair, I have one more motion relating again to SALN and unexplained wealth. I move that a subpoena duces tecum and ad testificandum be issued to the following: a representative from the Securities and Exchange Commission, and to bring certified true copies of the general information sheet and audited financial statements of the following entities: Metro City Chow Foods Corp., formerly City Hall King Chow Foods Corp., for the years 2007 onwards; GenCorp Industries Inc., formerly Times Square B Foods Corp. And Great Jolly Times Food, for the years 2021 onwards; Carpio Lawyers, formerly Carpio Duterte, for the years 2007 onwards;
So grabe, negosyante para talaga si Sara, sa kasawa niya.
888 Bistro, for the years 2021 onwards; Kale 88 Foods Corp., for the years 2021 onwards; Madayo
Wala na
Fisheries
sa
Corp.,
complaint mga
for the years 2021 onwards; Mati City Ice Plant and Cold Storage Inc., for the years 2023 onwards; Amian Shores Inc., for the years 2023 onwards; Geometry Security and Investigation Agency Inc., for the years 2023 onwards; and Cable Tow 88 Shipping and Marine Services Inc., for the years 2024 onwards. So moved, Madam Chair.
There is a motion for issuance of subpoena ad testificandum to the representative of Securities and Exchange Commission, as well as of subpoena duces tecum with respect to the general information sheet and annual financial statements of the business establishments mentioned already by the Honorable Ridon. Do I hear a second? The same has been seconded. Is there any objection?
Madam Chair, objection. And
You're recognized,
the
Honorable
grounds for
Rodriguez.
objection. May I know first why these companies registered with the SEC will be subpoenas in its record? Is there a nexus between this to the allegations in the complaint, third and fourth complaint? May we know the relevance of these corporations to the present impeachment case against the Vice President?
The proponent first, Honorable Ridon, followed by the Honorable Keith Flores.
Sige,
Yes.
Flores, mga taga-Bukid.
Mahalaga po yung pagpapaliwanag mula sa una, sa mga kinita po ng mag-asawang Duterte Carpio from their own personal income, which will be reflected from the annual income tax returns. Pangalawa, mula din po doon sa mga corporate documents kung saan po sila kasali. Sapagkat doon po natin makikita kung yung pong mga other lawful income para maipakita na ang lahat po ng kanyang kinita over the course of 17 years from 2007 ay mga lehitimo pong kita mula sa sahod at mula po sa kinita mula sa propesyon at mula po sa mga negosyo. So, meron pong clear relevancy. Ito pong mga SEC documents po na ito.
Ang unang problema mo dyan, Ridon, ay hindi nakasulat sa reklamo mga yan. Kaya hindi mo pwede isasama. Ang ultimate facts, wala sa ultimate facts mga yan.
Dahil dito natin makikita kung kumita ba o hindi ito pong mga kumpanya na ito, sapagkat kung kumita po ito, maipapaliwanag ng atin pong pangalawang Pangulo at na kanya pong mister na talaga pong kumita ng tama over the course of 17 years from other lawful income katulad ng propesyon at iba pang mga negosyo ang kanila pong pagsasama. So dito po maipapakita ng atin pong pangalawang Pangulo na hindi po unexplained wealth. Ito po nga kanyang pagkakaroon ng 88 million na net worth in 2024 kumpara po sa kanya po kinita na cumulative.
Problema kasi sa iyo, Ridon, hindi napasama sa reklamo ng nagsampa ng reklamo. Dinugtungan mo lang, SALN sa 2024, ikaw lang gumawa nun. Bawal yon sa inyong proseso. Ibig sabihin po, double standard kayo. Kay Bongbong Marcos sa impeachment, hindi kayo nagdagdag ng mga ebidensya. Pero kay Sara, nagdagdag kayo ng ebidensya na sarili sa inyo. Dapat ang ebidensya ay manggagaling lamang sa nagreklamo. Dito, ang ebidensya nanggaling sa mga congressmen mismo.
Relatively sahod from 2007 to 2024 na more or less mga 30 million to 40 million pesos lamang po, Madam Chair.
The Honorable Flores.
Thank you, Madam Chair. Madam Chair, I'm joining the objection of Congressman Rufus Rodriguez only on the following grounds, Madam Chair, that the request being made by Congressman Ridon covers periods when the respondent was not yet the Vice President, Madam Chair. I'm going back to the decision of the Supreme Court when it said that we can only file impeachment complaints against an impeachable officer for things done during the incumbency or while she is holding the impeachable office. So by requesting documents or data or figures that would include the time when she was just vice mayor, I think, in 2007, or holding other positions that are not yet or maybe considered impeachable, that's where my objection is, Madam Chair.
Honorable Ridon, would you like to comment to that?
Tama naman po yun. Pero what we would want to be able to see is a complete financial picture of the Vice President from the time that she commenced the public office in 2007 as a Vice Mayor up until today. That would be a proper objection with due respect if we had ended our request previous to 2022. But to be clear, I think a big chunk of all of these businesses' requests will most definitely cover up until today, Madam Chair. And more particularly, there are specific firms here which basically cover the term of the Vice President already. Geometry Security, Amianan Shores, Cable Tow are some examples. But to be clear, all of these are firms that had been listed in the 2024 SALN, which is why I think the nexus between the documents of the SALN and the corporate records is established as we speak, Madam Chair.
Would you
Madam
like to
Chair.
make additional manifestation?
May I secure from Congressman Ridon a statement of ultimate facts in the third and fourth complaint, which mentions these corporations? Are there any? None.
There is none.
None. Second, are there annexes that would show in the third and fourth complaint that would, mention and that would pertain to why you are going to ask for subpoena ducis tecum to the SEC and for the records there? Are there annexes in the complaint?
There is none.
Madam Chair, clearly this will be the biggest fishing fleet expedition that we are doing. Because it was, we only deal with ultimate facts. In fact, we are trying here to determine whether there is violation of the 6 grounds of the Constitution as stated in the 2 complaints. And so therefore, how can we have that, Madam Chair? So that's the first one. Secondly, did I hear from you that you want records from a law office? I heard something because this is new to us. This is a surprise to us, all of us here, that they are now a subpoena for entities that are not included in the complaint. So are you saying there's something about a law office?
To be clear, these are in the SALN of the Vice President for 2023 and 2024. So I think there is nothing that prevents this committee from basically issuing subpoenas on documents that that are actually public documents, Madam Chair.
No, I'm asking specifically. There was a statement. You're asking for subpoena for a law office.
Yes, because our assumption is that this is an incorporated law office because it was stated as one of the business interests of the Vice President in her SALN.
Aware of the privilege communication between lawyers and client? This will exactly violate the provision of privilege. You cannot subpoena law firms for representing a person either accused or in impeachment cases. How can we subpoena a law firm for acting as a lawyer for the Vice President? Can you give us a reason why we should subpoena law firms under the rules of court and under the Code of Professional Responsibility? We cannot subpoena records of a law firm.
Sure, court records or communications between clients and the lawyers are absolutely privileged communications. But if this particular law firm is an incorporated entity within the Securities and Exchange Commission and had been submitting annual audited financial statements year after year and general information sheets, I don't think we are precluded as a committee, as an impeachment proceeding, from requesting these particular documents. We are not talking about conversations between the clients of Duterte Carpio or Carpio lawyers. We are talking about their financial output year on year. And to be clear, this is precisely the justification of supporters of the Vice President as to why her net worth, had ballooned to 88 million as against a computed cumulative salary of 30 to 40 million pesos. So I don't think there is reason to, in fact, object to getting all of these financial documents, whether from a corporation or whether from a law firm that is supposedly registered in the Securities and Exchange Commission.
Madam Chair,
May I call the Honorable Jokno first?
perhaps it would be more prudent if we could have the motion of Representative Ridon in writing so that we can consider all the angles and the aspects to that request. I think that we would need to tread carefully when it comes to these matters, especially given the points raised by Representative Rodriguez.
Motion, hearing suspended.
Hindi, ang nangyari ngayon, napahiya kayo. Si Chiljokno, siguro na sampal siya, na talagang bawal po, ilang beses na nagdesisyon ng Supreme Court niyan, na talagang bawal po na buksan ang mga bayad ng mga kliyente ng abogado sa kanilang abogado. Gusto niyang kunin yung records ng pera ng law firm nila ni Attorney SARA Duterte tsaka ni Attorney Manasseh Carpio. Paano na lang ang mga kliyente nila? Mabuyagyag ang kanilang usapan sa pagbabayad ng kanilang mga pera nila hinahawakan. Kasi bilang law firm po, ang hinahawakan po ng mga abogado ay hindi lamang po yung kinita nila. Madalas po sa mga abogado, akala mo mayaman kasi marami ang tinatawag na malaman ang kanilang bangko. Pero marami pa sa mga abogado na ginagawa ko rin yan na nagdideposito ng mga account, nagdideposito ng tinatawag na pera sa kanilang account, pero ang katotohanan pera ng mga kliyente nila na tinatago lang. Ang tawag diyan deposit interest. So kung gano'n, kung deposit interest, with more reason na hindi nila pwede kukunin yung records ng bangko ng law firm o di kaya ng abogado sapagkat kasama dyan sa deposito yung deposito para sa kanilang kliyente. Ganun po ang lawyer-client relationship. Ilang beses na po nagdesisyon ng Supreme Court. Kasama po sa usapan kung magkano babayaran ng kliyente sa abogado, kasama sa mga naging bayad, kasama lahat ng detalye tungkol doon ay hindi po pwedeng maaring buksan. Ayon yan sa Supreme Court na pailang ulit-ulit na desisyon. Otherwise, kung papayagan natin buksan yan, wala na pong mga kliyente na magtitiwala sa mga abogado. Kaya nga binigay ng ating prinsipyo sa batas at ng Supreme Court ang total secrecy sa gitna ng kliyente at abogado ay para ma-encourage, para maudyok ang mga tao na magtiwala kayo sa inyong mga abogado at sasabihin ninyo ang katotohanan ng lahat sa inyong kaso, mapa-criminal case man, mapa-civil case man, mapa-administrative case man, para sa pinakadulo na pakay na nagsasabi, let truth be established. Paano mo ngayon makukuha ang katotohanan sa mga kaso kung takot na ngayon ang mga kliyente magsalita kasi sa kanilang abogado? Takot na sila ngayon tumapat sa kanilang abogado dahil ay pipilitin sila na ibuhay ang kanilang sikreto.
The motion. This is with respect to the motion of the Honorable Ridon for the issuance of subpoena ad testificandum to SEC representative and ad duces tecum, subpoena duces tecum with respect to the GIS and audited financial statement of certain business establishments mentioned already by the Honorable Ridon. Since we have heard already the arguments of both the proponent and those who are against, we shall now proceed to vote. We are reminded that we are a collegial body. All decisions come
Dag na naman na additional na ground para sa inyo na para mananalo na naman si SARA sa Supreme Court.
from the majority. So the justice members are reminded to be ready to vote. Again, the motion is to issue subpoena ad testificandum to SEC representative and subpoena duces tecum with respect to the certified true copies of GIS and AFS of the business establishments mentioned already by the Honorable Ridon. Do I hear a second?
Biro mo, inaamin na ni Raydon na hindi kasama sa reklamo ang mga sinasabi ng mga records na hiningi niya. Tapos, boboto pa kayo dyan? Grabe kayo. Sarili ninyong rule ay inyong nilalabag.
The same has been seconded. Is there any objection? There is an objection. Those who are in favor of the motion, please raise your right hand.
Aba, marami, ho. Mga kupal, oh. Sama si JJ, oh. Suarez. Kasama si Paulo, oh. At saka si Ilago. Oh, kasama ito mga congressmen, oh, si Eming Pascual, oh. Ay, sa Gapan, huwag nyo na iboto si Pascual. Oh, yun, si Antonio Tinio, mga NPA. Ay. Ano yung mga
You may put down your hands. Those who are not in favor of the motion, please raise your right hand.
Ang 2 million na Eastern Sunday bonus.
Thank you. Those who abstain, please raise your right hand.
May abstain. Kunwari, abstain pa kayo.
That concludes our voting. We shall announce the result.
Wala na. Ano itong inyong mga binoto na Congress?
With 14 votes in the affirmative, 2 in the negative, and 3 abstention. The motion is hereby declared granted. The committee secretariat is directed to issue the necessary subpoena ad testificandum to the representative of SEC and subpoena duces tecum for the production of GIS and AFS of the business establishments mentioned in the motion of the Honorable Ridon. So ruled.
Ano pa? Sige. Lubos-lubosan nyo na. Lubos-lubosin nyo na. Sige, lubos-lubosin nyo na. Sige. O, ano pa?
May we know if there is a representative of the respondent, Vice President SARA Zimmerman Duterte, to inform the committee about the necessity of issuing the compulsory processes with respect to the witnesses she wishes to present and the documents she wishes to present as well to the committee. The chair wishes to state for the record that despite the non-attendance or non-appearance of the Vice President and her counsel in today's hearing, they are welcome to participate at any stage of our proceeding. That is in pursuit of due process which we accord to the respondent in this impeachment proceeding. Having said so, are there any other matters?
Madam Chair.
Madam Chair.
Madam Chair.
The Honorable D.S. Konghun first before the Honorable Marcoleta.
Thank you.
Madam Chair,
Kung
for the purpose of our next hearing on April 14, 2026, the committee should consider adopting the sequence of the grounds for the third impeachment complaint and receive the evidence for both impeachment complaints jointly, considering that they may have in common evidence. I propose that for our hearing on April 14, the committee should determine the probable cause for the following grounds for impeachment. Number one, the Sabala complaint, the Vice President committed culpable violation of the Constitution and betrayal of public trust, malversation, graft, corruption, and other high crimes. The Cabrera complaint, the Vice President committed betrayal of public trust, graft, and corruption. Number two, for the Sabala complaint, the Vice President committed culpable violation of the Constitution and betrayed the public trust by committing malversation, grafts, corruption, and other high crimes. The Cabrera complaint, VP Duterte committed graft and corruption, bribery, procurement irregularities, and command responsibility. Number three, that VP Duterte committed capable violations of the Constitution and betrayed the public trust by corrupting and bribing officials of the Department of Education. And for the Cabrera complaint, that the Vice President committed bribery, procurement irregularities related to corruption in the Department of Education. Madam Chair.
May we confirm if that is your motion already, the Honorable D.S. Konghun?
Yes, Madam Chair.
So there is
I
a
move.
motion to adopt the sequence of topics already read by the Honorable D.S. Konghun for the purpose of our determination of probable cause.
Madam Chair,
The Honorable De Lima.
it was not quite clear to me which specific grounds indeed are to be first tackled for the April 14 hearing. The movant or the proponent actually made mention about culpable violation of the Constitution, betrayal of public trust. But which of these specific grounds? The first ground, I'm talking about the Cabrera, the Saballa et al. Complaint. The first ground is about the anomalous disbursement of confidential funds for the OVP. The second is anomalous disbursements of confidential funds for the DepEd. And the third ground is bribery and other graft and corruption. And those three grounds are actually covered by the 5 motions for subpoena that I put forward and already approved. So those witnesses, those resource persons, subject of the subpoena, will be tackling these first 3. Anomalous disbursement of confidential funds, OVP, anomalous disbursements of confidential funds, DepEd, and the bribery and other graft. So it was not clear to me, the manifestation earlier of the proponent. Is he also referring to these grounds?
The Honorable Dilemma is asking if the proposed sequence of topics pertains to 1 confidential fund of DepEd, 2 confidential fund of OVP, and 3 bribery in DepEd.
First OVP, then DepEd, then bribery.
Yes, Madam Chair.
The Honorable Diaz Conjun confirmed to that, Honorable Dilemma.
Thank you for the confirmation, because that is also the intended sequence insofar as the complainants are concerned in the Sabalia et al. Complaint. Thank you, Madam Chair.
So can
Madam
we rule
Chair?
on the motion? The
Madam-
Honorable Rodriguez.
Yes, Madam Chair, I'd like to be clarified. In the third complaint, there are 6 grounds where we have found, the committee has found the form, substance, and grounds sufficient. Also, the 5 grounds in the fourth complaint. How do we hear this? 6 grounds, third complaint, and 5 grounds of the fourth complaint. Are we going to go one by one for the third and then the fourth? We're going to mix, because ground number 1 is ground number 1 also of the fourth complaint. Ground number 4 of the fourth complaint is ground number 2 in the complaint. So are we going to mix them if they have the same subject matter, or we will go, because I'm not clarified on this, or we will go by grounds per complaint, Madam Chair? How do we go about this?
The way the chair understands with the proponent of the sequence of topics is that the allegations that pertains to the confidential fund of OVP, then DepEd, then bribery with in the DepEd are taken together, allegation by allegation, the third impeachment complaint and the fourth impeachment complaint, so that we can receive jointly the evidence which will be submitted by the parties in relation to these 3 topics: confidential fund of OVP, confidential fund of DepEd, and then bribery in the DepEd.
Yes, joint.
After that, Madam Chair, what will be the next to be heard, so that we will know how we will go along with this hearing? So I understand 3, that's fine, because confidence.
Stop na natin siguro dito. Ay wala nang kwenta pinag-usapan eh. Hindi na ano yun, hindi na masustansya. So nagpapasalamat ako sa inyo at mahaba yun, 2 oras, magta-3 oras tayo nanonood dito. Tapos maraming salamat, mag-like po kayo lahat para sa sunod na pag-live ko ay ma-notify kayo. At kung maaari lamang, mag-subscribe kayo po sa akin at para matutulungan, total libre naman. At kung maaari din, mag-follow kayo sa akin sa Facebook, follow kayo sa akin sa TikTok, Instagram, at saka sa Twitter. Maraming salamat po at magandang hapon sa inyo lahat.